Good morning. This time it's been set for a special meeting of the Cannabis Compliance Board. This is February 15th, 2023. First, our order of business, as always, is call to order. And then the roll call.
I can handle that. Member Merritt? Member Durrett?
Here.
Member Freilich?
Present.
Dr. Young?
Here.
And Chair Douglas.
Here. For the record, Chair Douglas, we have one new member. We're very pleased to have Ms. Freilich as our new board member. We are sad to see Mr. Nylander move on, but that is the nature of life. The only thing certain is change. So welcome. Even though this is strange circumstances to welcome you, but welcome in you. First order of business, as always, is our public comment. If we have any public comment this morning. Any public comment in Carson City? Seeing none, we will then move our agenda. Item number 2, adjudication of disciplinary action. Item A, Cannabis Compliance Board versus Cannabis Nevada, now known as the Tooth Test LLC. This is case number 2020-27 for possible action. Before we get started, a couple of things. First is that in terms of the hearing today, the position that I've thought was the best way to handle the hearing is that we, the board, would make a decision, whether it's today or following meeting, depending on the pleasure of the board after hearing the information, would deal with only the issues as to whether or not violations have been committed. Thereafter, once that decision gets made, we would proceed to what type of disciplinary action, if any, is appropriate. So it's a bifurcated hearing. We thought that best not to confuse issues and get into whether or not how much mediation, how much things have changed or not changed, or appropriate or inappropriate or dollar amounts today. So we could center on the factual issues of whether or not, in fact, a violation did occur or didn't occur. So having said that, the next order of business, just since I have, and the other members of the board have, about an 8-inch stack of paper in front of us and a book in front of us, with hearing documents. And I guess the question I have is, are these all documents that are part of the record? Are they documents that are not part of the record? For clarification.
Excuse me, Chairman, this is the court reporter. Can you get closer to your microphone, please? It keeps cutting in and out.
All right, thank you.
Thank you.
Ms. Russian, did you want to?
Good morning, members of the Cannabis Control Board. I'm Kimberly Maxon Rushton with the law firm Cooper Levinson, appearing on behalf of Lettuce Test LLC, otherwise referred to as LTL. Joining me today on behalf of the company are the owner-operators, Mr. Rick Rushton and Mr. Rob Richardson.
Good morning.
Also here today are the scientists and employees of LTL. I could just acknowledge them. Thank you. And then also joining me is the scientific lab director, Dr. David Luttrell. So in response to your comment, Chair Douglas, I would note the fact that I did prepare a hearing exhibit packet in preparation for today. It contains 13 specific exhibits, the majority of which are within your files. And if you don't mind, I can just simply walk through those very quickly without going into a lot of detail.
Ms. Rushton, I asked the question because what is appropriate for this hearing in terms of exhibits would be, unless they were just purely demonstrative of showing something, are things that have previously been before the hearing officer. This is not a hearing where we're going to accept material documents, especially since this has not been previously provided to the board for review. Put that's the position.
So again, I would note the fact that the Exhibit 1 are the public notices, the health notices that were issued by the Marijuana Enforcement Division in 2019, 2020. They were one public note. You can take judicial notice of these because of the fact that they were public notices. They were also a very integral part of the summary suspension. And with all due respect, I think that that's where the delineation and the divide is with.
Ms. Rushing, the rules are, as you have been very good quoting rules to us, the rules are fairly clear in terms of we're dealing with the information that's provided. This is why you're objecting. This is why you wish to present your review to this court saying that there were errors in the record. If it was material that was not presented in the hearing below, it's problematic in terms of coloring why the decision got made or didn't get made. I don't know, but that's why we're not in a situation looking at this, especially since there was adequate time prior to this hearing to present this information and why it was from the state in the books an emergency or of some nature that it wasn't available previously, why it should be accepted by this board at this time. That does not mean that some of this information would not be allowed in pure mitigation as to why the board should or should not do something later if it's appropriate. But in terms of determining what were the facts that were presented, it's really difficult. So if you confine your record to things that are in evidence to the hearing officer, it would be greatly appreciated.
In response to your question or your comments, Chair Douglas, I would note the fact that we specifically argued in the objections the fact that the record was incomplete, that the hearing officer had failed to include any procedural history relative to the summary suspension that initiated this case. And so the documents before you primarily deal with the summary suspension because it is a part of this case. It started the case and it continued. Throughout the 7,700 pages of evidence that were provided to us, it is replete with references to documents or to the summary suspension. So there are notices that were given. There were identified samples that were retested, and those are contained in Exhibit 96. So you cannot separate the summary suspension from the complaint. It's a part of the matter. And so
Summary suspension in part is part of the complaint. Summary suspension is not part of the complaint. They're intermixed. Understanding your position with that as they flow in or out, but there's a summary suspension and there's a resolution. Canex was allowed to go back to open back up and operate. That ended the summary suspension. It did not preclude the agency, rightfully or wrongfully, and that's part of what we're here today to determine, of going forth if they saw fit with alleged, is that term, disciplinary infractions. So we'll give you some leeway. I understand other comments you wish to make, but please, if something was not in the record that was offered to the hearing officer. I note I did not see when the other motion was argued, I don't recall really specifying specifically what was not allowed. But that's just an old person saying.
it is detailed in our objections. So I note again for the record the fact that as you've articulated, there was a finding of fact, conclusion of law, and a recommendation made by the ALJ. And then the parties were given the ability to submit objections to that. I submitted a quite lengthy objection, noting the procedural errors, noting the fact that there was ample discussion and evidence that specifically dealt with the summary suspension that she had not included in her recitation of the procedural history of the case. In addition to that, I note the fact that there was a decision by this board upon the motions to dismiss that res judicata did not apply, that did not conclude the matter, the summary suspension. But included within the summary suspension, members of the board, is the corrective action plan. And we cannot move away from that because that's a critical part of this case. So as the summary suspension was concluded, it was only concluded based on the corrective action plan that was submitted and approved by Director Klimas in advance of that. We came to the hearing for the summary suspension, ready to proceed, and they respectively asked if we wanted to settle, and we settled the matter relative to lifting the summary suspension.
And that's a part of, well, you've kept referring to this as settlement. The document is clear on its face and it stands for what it stands for. It allowed Kennex go back into operation. It was not a settlement of potential violations. Clear distinction. I understand that's your position. But that's not what is part of the record as I see it. You can argue that if you wish. But coming back to the germane part of why I asked this first part, I would ask that you, if there's something that was not part of the record that was offered, please so note that for our record.
Be happy to.
Because in fact, afterwards, if there's a need by either side, ask for any kind of review, those things need to be clearly marked so that there's no dispute as to what was part of the record for the hearing officer, and what was not part of the record before the hearing officer.
And if I could just close the loop on one point that you did make, Chair Douglas, with respect to the timeliness of this. We did request to see the board materials. Those were provided to us approximately 2 to 3 weeks ago. We went through those. I mean, you can see the volume, but
Ms. Maxon, you make a point.
Yes, sir.
I understand that, but there's been adequate time. It's not like this has been on a fast track hearing. It's been on a snail's track. So there's been adequate time to review, to double review, to side review, anything else. So just from a standpoint of frustration, I don't like personally getting stuff at the last minute and having to sort through, especially when, what is it, 700-800 pages worth of material that we're expected to understand and review at this date. It's just burdensome, and as was complained of in moving papers on your part about a fair hearing, it taints the process as to fair. So having had that, unless there's something else you want to give us about the exhibits, and I've given you parameters.
Sure.
Counsel for the state, if they wish to make any representations,
Thank you.
can move forward with the hearing this date.
Chair, if I could, on the document issue first briefly.
Yes.
Thank you. Good morning, Chair, members of the board. Welcome, Member Freilich. L. Christopher Atz, Senior Deputy Attorney General for the Cannabis Compliance Board. And I strictly want to just briefly address the document issue here. We did have objections to many of the new exhibits that were added. I can either go through them one by one now, or I can raise them when they come up. But just as a general matter, they were produced at the last minute, over 700 pages, about 280 of those pages were California regulations, and I don't see any relevance to those since we're in Nevada. As to the summary suspension, as you're aware, it's over. The first 2 exhibits, the parties put in relevant documents into evidence as exhibits that may have pertained to the summary suspension. If they're in the record, I'm fine with them, and I didn't object to all of these. But the first 2 are not in the record. They could have been offered as exhibits at the hearing. It wasn't done. So, I mean, we're objecting to numbers 1, 2 for those reasons. Number 5 as well. Again, the summary suspension is over. And to the extent there's some exhibits that the parties admitted, that's fine. Number 5 was not admitted. There are unadmitted exhibits, which I understand can be part of the record. So we just preserve our objections we made at the hearing on those. There's a lab document about accreditation, which was not in the record. And the regulations specifically state inspection by an accrediting agency is not a substitute for inspection by the department. So I don't see how those come in. Just a couple others.
What I would ask then is if you keep objections as those documents come.
I can certainly do that. And then briefly with respect to ours, we just gave you an exhibit package. The first exhibit is the hearing officer's findings of fact and conclusions of law. That's in the record. I haven't heard any objection to that. It's simply for your ease of reference if you need to follow along. The second one is a June 24, 2022 statement of deficiencies letter that was mentioned within one of our motions that is in the record, but there was not a copy of it. I have not heard any objection to that. And that's simply for rebuttal to the statement that was made in the one of respondents pleading, quote, the fact that LTL has not been issued a statement of deficiencies nor complaint pertaining to its operations since 2019 is prima facie evidence of respondent's compliance. So that is why that was offered. I have not heard an objection to that. By the way, I did provide all my objections to respondent's counsel. And I'll get to that when we get into the arguments or rebuttals. The third exhibit we provided, I may not even need to use. It's simply if Ms. Rushton is going to get in this accreditation certificate, it would be a rebuttal to that. That covers up what we have in our packet.
And as I advance to Ms. Rushton, likewise, in terms of your proposed exhibits, as if they were not part of the record below, unless we allow the other to come in and there's a need for that, they would not come in this date.
Okay, and I'll reference them as I go through my argument.
And for the record, and clearly afterwards, these will need to be marked so they're properly part of the record, and need to note that anything that was not part of the record has to be distinguished from those things that are part of the record, so that there's no misunderstanding later when someone else sees them for the first time of what was in and what was not in the record.
Thank you, Your Honor.
So with that, unless the parties need a short 5-minute break before we go forward, we're ready to go forward and hear our. Technically, Ms. Rushton is the petitioner. She is objected to the decision. It would be appropriate for her to go first.
I think the notice indicates that as we have the burden of proof.
You have the burden. This is objections to the record of the hearing officer. It would be appropriate to hear what those objections are and for the state that they're after comment as to why that's not appropriate. And Ms. Rushton have be allowed a certain amount of rebuttal thereafter. That's pretty much how we proceed this day.
Okay, if you would like to proceed that way, that's fine.
Thank you again. For the record, I'm Kimberly Maxson Rushton, appearing on behalf of Lettuce Test LLC, otherwise referred to as LTL. Any story sounds true until someone tells the other side and sets the record straight. Proverbs 18, verse 15. It's hard to know where to start with this case because of the fact that it is so glaringly incomplete. The record you have before you is not complete, and the violations complained of are not reflective of the licensees before you. The difficulty with this case is that optically it looks bad. You've got a significant number of exhibits that were provided by the state. You've got 300 plus pages of transcript and multiple days of hearing. And throughout the course of this, as I've noted in the objections, we repeatedly complained about the errors, procedural errors that were being committed by the administrative law judge. Specifically in the objection I set forth, and I break it down, one, the objections to the ALJ's actions. And that began specifically back when the summary suspension started, but then it elevated obviously at the time of the hearing. Specifically, what happened was the fact that we requested to call certain witnesses and we were denied that ability to call those witnesses. Specifically as it applies to the scientific lab director that is currently with LTL, Dr. David Luttrell, we were denied or prohibited from calling him based on the fact that the description of his position and what he would testify to was not clear. So as you'll see in the records in the pleadings, we identified him as the scientific lab director for LTL. and that he would speak in defense of the complaint. But that was not clear enough to the opposing party as to what he might testify to, so he was precluded from testifying. I would respectfully submit to you that if you heard from Dr. Luttrell, who is here today, this entire case would change drastically. He is a seasoned cannabis lab operator. He is an adjunct professor in Arizona. He is a published lab director and expert with respect to cannabis testing. He can very easily explain the actions of LTL, the scientific basis for that, and why we respectfully disagree with the charges as set forth in the complaint and the findings as set forth by the ALJ. In addition to that, we were also precluded from calling Chief Kara Cronkite and Director Klimas. And the reason why we thought that that was important is because of the fact that based on the testimony of the witnesses from the state, decisions made relative to the summary suspension and the issuance of the complaint and the issuance of the public hearing notices or the public health notices were done, or those decisions were made exclusively by Chief Cronkite and Director Klimas. And so the question was, why did you do this? What was the basis of it? And that's where the public hearing notices come in. And again, we can certainly get into it, but what you'll see is the fact that you've got a disparate treatment with respect to how LTL was treated from the beginning and throughout the process. In addition to that, members of the board, we were denied the ability to present relevant evidence. Specifically within the statute and the regulation, it talks about the ability to present evidence as you become aware of it, not only before the hearing, but during the course of the hearing. But yet, this was treated like a trial. We had a pre-hearing conference, and you were to give the statement and supplement with respect to your witnesses and the evidence you intended to present. And if you missed that date, didn't come in. I would speak respectfully in the fact that when you're talking about a licensee's license, possibly revoking it, suspending it, or otherwise imposing a significant fine, all relevant evidence should come in. This is an administrative hearing. As a seasoned administrative attorney, I can tell you I've never seen a hearing that was so regimented than this one. And we would repeatedly request to have evidence submitted in response to that was being presented by the state, and we were denied. And so the information that is contained in Exhibit 6 of your packet, those were the exhibits that we proposed. And as you'll see in the transcripts, at one point during the testimony towards the end of the hearing, we respectfully requested to, again, for reconsideration of the exhibits that had been previously denied. And the judge just said, I'm not going to take any more exhibits. You had your chance. You don't get to. That's not what the law allows. And so specifically for those reasons, we submit to you the fact that the record before you is not complete. We were not allowed to present the evidence in defense of the complaint. We were not allowed to call witnesses that would have explained the actions of LTL from a scientific basis. And we were not allowed to determine what the basis of the summary suspension was in the health notices, when to date, there's still never been any medical reports, any health reports, or any claims submitted to the CCP that there was cannabis that was harmful to the public. So what was the basis of that? And that's the theme that carried throughout until today. And so the objections, I think, are extremely important relative to the fact that this is an incomplete case. And the errors that were committed are reversible errors that in a court of law would mandate that the case be remanded back for a new trial or for further consideration with respect to specific acts. And so that's where we start. And that's a difficult position because of the fact that, again, we're here before you 3.5 years after the summary suspension, defending the actions that on December 9th of 2019, state complained about and LTL stopped. So we went into the summary suspension. We asked for the statement of deficiencies. We asked for a global finding of all of the findings that the state made during the inspection and audit, and then we prepared the corrective action plan and submitted it. And as you have in your record, it was accepted by Director Klimas, and we were then to go forward and put those in place. And so the fact that the record fails to include that procedural history is significant because, as I've articulated before this board on prior occasions, compliance is the gold standard for administrative agencies. With all due respect, licensees should not fear regulators. They should respect them. And the reason why is because if they respect them, then they self-monitor, they self-report, and they adhere to the high standards of compliance. But compliance in an administrative setting is akin to an affirmative defense. Licensees are going to get out of line. It happens. Document isn't completed properly. You don't put the red banner around the terms R&D on a COA. Those things happen. But what's important is that when these things are brought to the attention of the licensee, that they acknowledge them and they correct them. And in this instance, again, it would have been very important to have Dr. Luttrell speak because of the fact that he would have explained that the actions that were complained of and that the findings from the December 2019 audit were really not significant. They were things that were the basis of a difference of interpretation. And I would submit to you that when you look at the regulations and the findings as made by the judge, they don't match up. I mean, we'll just start with paragraph 83 that specifically deals with training. So there's a requirement in the law that mandates that every marijuana establishment undergo 16 hours of training, 8 hours in-house, 8 hours external. But the law says that it's to be done at the direction of the board. So you have a licensee that's been licensed since 2016, never been directed to go and do the external training. And you can somewhat understand why, because of the fact that it's a lab, no money, no samples really to take and utilize for personal consumption. And you don't have the same safety concerns that you have at your other establishments. And so when they were told to do it, and that was pursuant to, again, the statement of deficiencies that we specifically requested, within 10 days it was done. But yet the judge finds that there was a violation. But if you look at the violation that she cited, it was for having alcohol on the premises. I mean, that's what this case is about. If you go through that complaint and you look at it, in and of itself, it's confusing. And then if you look at the exhibits that were provided, there's no order to those. There's nothing that matches up. You have to go through and find the information. And so we're talking about the fact that, yes, we did request an expedited hearing, but this was what was dropped on us. And so we learned at the hearing what the relevance of most of this evidence was. And that goes back to the procedural infirmity. Therein, based on those arguments, the ALJ should have acknowledged the fact that we, as the licensee, even though the other side carries the burden, we have the most to lose. We have a license on the line here, and yet precluded us from submitting information and evidence that we thought was relevant, calling witnesses. The other fundamental flaw with the ALJ's actions was the preclusions from allowing LTL to review the state files. The law specifically states that we're allowed to look at the files once the AG or the state puts that information into the record. They put the information into the record, clearly, but they only gave us part of it. We submit that there is exculpatory evidence in the state files that, again, would explain a majority of the complaints before you. We have testified, and the record is very clear, of the fact that during that 3-day inspection period in December of 2019, that the agents came in with their phones on and out and recorded every bit of that. You saw 2 pictures. And when we asked them about the videos, well, I don't know, it could be fuzzy. I mean, all of the witnesses from LTL said, I was present, I was intimidated, I was interrogated, and they had their phones out, and that's what happened. And yet you have no videos of that. It wouldn't make any difference if you saw the surveillance videos from LTL. You need to see the videos of the interactions and hear the tone in which they spoke to the employees of LTL. They put a lot of emphasis on the testimony or a statement by a technician by the name of Ozzy Ruiz. Ozzy was a technician that had been there for less than 6 months. He was not a scientist. And that is at least 4 counts of the complaint before you. One pertaining to the Delta 8 and the others pertaining to the inability to properly supervise and train. So you have scientific evidence demonstrating that LTL tests for Delta 8 as required by the law. You have the schematics from their instrumentation showing the settings for the Delta 8. You have the scientist, Kelly Romolina, who is here today saying, I set up the machine, I helped draft the SOP, I trained on the Delta 8. But the fact is that that didn't matter. What was important to the hearing officer is the fact that Investigator Perez said that she talked to Ozzy and Ozzy didn't know about it. He was training. That is not reflective of LTL. And so when you look at the weight of the evidence, therein lies additional problems. At what point do you give more weight to an investigator who is providing hearsay testimony than the actual operators of the lab who say, we set it up because in October of 2018, we received a notice saying that Delta 8 is now required as part of our potency testing. We ordered the PT, we didn't get it, and that's a proficiency test. That's what you have to do in order to demonstrate your proficiency in testing each of the quality assurance tests that are obligated by law. But the machine was calibrated, the SOP shows it, every COA shows it, and the scientists explained this, and yet we still have the finding by the ALJ. I mean, that should have never even been a complaint. But that in and of itself, as I'm demonstrating, is the fact that had you heard from Dr. Luttrell to explain, again, calibration of the machine, how it works, and the supervision and training that was done at the time, it would have changed the course of this hearing. Had we been able to access the state's files, seen the recordings, seen other information in there that we believe is exculpatory, it would have changed the course of this hearing. So I think it's important, again, that you look at the objections as noted by the respondent because of the fact that those clearly set forth what the obligations were relative to the ALJ in ensuring a fair hearing, and then those things that were denied to LTL and therefore prejudice them to a point that it's not just harmless error. I mean, individually, I would say that these are reversible error, but collectively, they are clearly reversible error. Make no mistake, we do not want to go back to hearing. That is not the objective here. It's to, as Chair Douglas noted, just simply point out the arguments and the objections that we have specific to the ALJ's findings. But I think that that's very critical because as we go through these counts and argue what the flaws are, it's demonstrative of the fact that, again, had you had a complete picture, I guarantee you we would not be here today. And so I'll start with, again, going through the objections as noted. And I will say, and based on Chair Douglas's comments relative to deliberations in terms of discipline and everything, my first point that I wanted to make this morning was the fact that I can easily resolve this case. I can propose to you, based on all of the counts, exactly where this case should land and exactly what the best course of action is going forward. Because again, as regulators, what you want to see is one, compliance, two, a licensee that understands the obligation and commitment to compliance and will go forward doing that. And that's why the ANAB most recent review was so important, because when you line up the complaint with the ANAB finding and everything from this past October, you see a glaring difference.
And Chair, I'm going to object again, this
I'll
ANAB.
sustain the objection.
So
We're part of the difficulty, and I understand the argument you're making, and I have chosen not to interrupt you, is as cited in the list of alleged deficiencies, what was going on in the facility on the date question. And it's not my role to make argument for either side, but that's kind of what's for us. We're having to look at it in that limited window at this point in time, where those allegations as to what happened, people identified, SOPs, things of that nature, banners with or without letterheads. What happened?
certainly. Well, and the reason why, Chair Douglas, I raised the issue relative to ANAB, and again, that is their proposed Exhibit 3, separating the specific document from the actual practice. So as the board is aware, all labs are required by law to be ISO certified. That's an independent certification that's specific to labs.
Ms. Maxon,
It-
that's,
It's a count.
that's something on the backside of you going through this. We need to hear. But on the front side, we need to hear specifically, if you can, and I understand this is part of your defense, so I'll give you leeway. But we're segueing into an argument that was kind of made in your moving papers in terms of the rules of the department versus other outstanding agencies' viewpoint of what the rules, and that you did this, but you didn't do this. So if you go through and explain to the board, it might help your
Certainly.
position.
So again, starting with paragraph 83, the alleged violation is of Nevada Administrative Code 453D.434, subsection 7GF. And as noted previously, that is the requirement that a marijuana establishment undergo 16 hours of independent training relative to security. The regulation states that it is to be completed within a period determined by the CCB. I would submit to you that LTL completed the training on January 27th, 2020, as part of the corrective action plan, 13 days after this was brought to their attention. Additionally, the law in effect at 2018, LTL and staff had never requested that they go through that type of security training. As I noted earlier, they've been licensed since 2016. They've been subject to annual audits. This had never come up. Now in 2019, it comes up when we request the statement of deficiencies. And as soon as we receive that, then the company goes out and does the required training. For that reason, we believe that there is no violation based on the fact that the law clearly says that it is to be completed within a period determined by the CCB. CCB raised it for their attention. It was done within 10 to 14 days. Paragraph 84, the hearing officer.
Can I get the citation again?
Yes, ma'am. It's NAC 453D.434, subsection 7GF.
I just don't remember the part where it says subject to the timing of the board or subject to the request of the board. Okay.
And if I could read it into the record. Each marijuana establishment shall ensure that the security manager or director of the marijuana establishment, at least one employee of the marijuana establishment, or the employees of any third party who provides security to the marijuana establishment has completed or will complete within a period determined by the department to be reasonable the following training. When the department notified member direct LTL that they were required to do the 16-hour training, they did it within 10 days. 10 to 14, I apologize. I believe that we were made aware of the statement of deficiencies on January the 14th, 2020. We responded on January the 16th with the corrective action plan. And as the evidence in Exhibit 6, which is the state's exhibits to the hearing, demonstrate by Invictus that training was completed on January the 27th, 2020. There was no violation found for paragraph 84, so I will move past that. Paragraph 85 is an alleged violation of 453D.745, subsection 4, the failure to close out the disposal of samples and metric. We acknowledged during the hearing that that was not done. We specifically stated that we acknowledged that that needed to be done and that it was not done. Also, what the hearing officer found, and as the evidence in the record demonstrates, is the fact that all other necessary documentation and recordation relative to the destruction of the samples was done properly by LTL. So you have your metric system in which it controls the seed to sale throughout the process. And then at the end of it, the lab is to go through multiple pages and scroll down and click the fact that the sample process has been completed. That button was not clicked. However, all of the documentation, as again found by the hearing officer, demonstrates that they did keep the proper recordation, demonstrating the destruction of the sample and how it moved through the course of the lab and then ultimately to being destroyed. And so with that, we note the fact that it was not done. And consistent with the recommendation as made by the ALJ, we do not believe it rises to a level of warranting 10,000 violations, but rather one for the single act, and agree or stipulate to the category 3 violation and a fine of $2,500. And again, Chair Douglas, depending on your preference, I can continue to go through these. And then also there is the issue relative to the stacking. So I prefer, if it's acceptable to the board, to go through, note what we believe the applicable fine would be for the offense. And
I
then,
would prefer that you actually stay with that at this point.
yes, sir.
And just deal with whether or not compliance, non-compliance, or as you pointed out, there's another reason something get done. So stay with this time.
Yes, sir. Paragraph 87 alleges a violation of 453D.776 subsection 4. This is the failure to add a red border around the term R&D on a certificate of analysis. The law states that on all COAs in which research and development is done, that you are to denote that on the COA, R&D, to demonstrate the fact that this is not a product for sale, and it is to be, those letters are to be enclosed in a red border. On 9 occasions, LTL failed to do that. We stipulated to that during the hearing, and again stipulate to the fact that that was a violation. I would note for the fact that the violation as found by the ALJ was of 453D.905, subsection 3D, 4, 8, and 13. At the time, the section 905 was the disciplinary proceedings or the categories. So that identified category violations 1 through 5. And as you're familiar with, it identifies specific acts that constitute a category 1, a category 2, and all the way through to a category 5 violation. In this instance, what the ALJ found is a violation that specifically, and again, this is where things get convoluted and everything. She stated that the violation for failing to put the red border around the terms R&D constituted a category 3 violation for failing to keep any required records, including seed to sale tracking. We dispute that based on the fact that there was a clear finding that the recordation was appropriate and was complete. She further found a violation of 8, subsection 8, allowing any activity which violates the laws of the state. I suspect that's the catch-all, and that would incorporate the R&D or the red banner. And then the last one was subsection 13, violating packaging or labeling requirements. This doesn't have anything to do with packaging or labeling, but we would acknowledge again that the borders were not on 9 of the certificates of analysis out of hundreds produced by LTL that year. And as a result, it is a technical violation of, again, the subsection 8 relative to, well, actually, she found that it was a violation of subsection 8, which is allowing any activity. Well, that's fine. So I apologize. That we will stipulate to. Paragraph 88 alleges a violation of 453D.788 subsection 9, and the fact that LTL reported partial results to cultivators prior to the issuance of the COAs. This is significant. What the complaint is the fact that LTL during the testing process gave out early preliminary results. I would respectfully submit there's nothing in the law that precludes that. I would also respectfully submit that, and just as a matter of background, the testing process in Nevada ranges from 3 hours to 72 hours. 3 hours for the potency. That's a very rapid test, easy to perform in a very short period of time. The longer test is the microbials because of the requirement that you have to incubate the sample. And so what the complaint was is that between that 3 hour and 72 hour, the expectation is that the lab is not supposed to talk to the cultivator, not supposed to tell them the status of the testing or any of the preliminary results that come back. So as the sample moves through the lab, you've got the chemistry sample, and that's going through with respect to the heavy metals, the pesticides, mycotoxins, you have the potency, and then you have the microbial. And as noted, the microbial takes a significant period of time and is usually the last test. And so the complaint here is the fact that LTL, when customers call to ask on the status, would tell them the status. Again, the law doesn't prohibit it. And as included in your hearing exhibit packets, this was a common practice done by other labs. The objective is not to call out the other labs and get them in trouble. The point is to demonstrate to you that no one interpreted this regulation to preclude a licensee or a lab from discussing the status of the lab results prior to issuing the COA. And the reason why it's not precluded is because of the fact you can't do anything with it. Until the COA is submitted to the state, to the cultivator, demonstrating that the sample has passed, there's no way you can do anything with it. You can't market it, you can't sell it, it can't be used, it can't be moved. So what does it matter if a cultivator calls and says, where are we with the testing? And the lab says, we're done with your potency, we're done with your heavy metals, still waiting on the microbials. Or are things looking okay with everything? Yeah, you're fine. Where is the violation there? She specifically found, the hearing officer, that this was a violation of 453.7889. That specific regulation is the requirement that a certificate of analysis be completed and submitted to the state simultaneous to being submitted to the cultivator. There is no language in that regulation or any others that states that you cannot have a discussion with your customers during the course of the sample testing. It does not in any way diminish the independence. It is strictly telling your customers what the status of their sample is and what results have come back and which ones are still waiting. We would respectfully again submit that the law as stated and the basis of the violation finding by the ALJ does not demonstrate a violation, that there was no violation of 453D.7889. All COAs upon completion of the lab testing were completed, submitted to the state via metric, and submitted to the cultivator as directed. There is nothing in the law, again, that prohibits a lab from having a discussion with its customers during that process. Moving to paragraph 89, this is an alleged violation of 453.905 3A3. This is extremely significant. In this matter, because of the designation on the COA, the hearing officer made a determination that this was a category 1 violation for intentionally misleading the CCB. There is nowhere in the law that requires a certificate of analysis to designate or to state what the flower or what the product being sampled is. Nothing. It says batch number, lot number, metric number, status of, or the panel of test. Now it requires a picture, but at the time it did not. And so what would happen is the fact that when a sample is requested to pick up, it goes through an online system called Confident Cannabis. The cultivator puts in the information and a request for the sample. They describe what the sample is. The lab goes out, it does its sampling, it weighs it, and then thereafter takes it back to the lab and performs its testing. That manifest as created in Confident Cannabis is done by the cultivator. And as it applies to distributors, it specifically says you may not change or alter the manifest. So this one's very interesting because of the fact that, again, if you look at the COAs in evidence, if you look at it, and this was the sole reason why I submitted the summary suspension documents, is because in that supplemental, you see a number of pictures of the labs that retested against LTL, and it will say trim, but it's a bud. It'll say flower, but it's a pre-roll.
And Chair, just to state my objection, any reference to documents outside the hearing should be precluded.
So no objection.
So again, this was not anything that was done I mean, it's almost interesting to even think about why this is a violation. Because from a testing perspective, it means nothing. Whether or not they test flower or trim, the only difference is the lot size. So that's in the actual sample itself, but how it is identified and on the COA is insignificant. And what's even more important is the fact that, again, you have a regulation that says that at the time of the pickup, you are to identify the condition of the sample. Condition is not the type of sample. Condition means, is it frozen? Is it wet? Is it dry? Is it brittle? That's the condition of the sample. That's what the law says. That at the time you are to check and ensure the measurement, and you are to check the condition. And then you look at the specifics relative to what goes on a COA. It does not say that you have to identify the sample. So where is the violation? And what is the significance? And when that question was asked at the hearing, the significance was, well, because there's a tax obligation, there's a tax differentiation. That obligation has nothing to do with the lab. The labs are not the taxpayers. They don't dictate by what they put on their COA what taxes will be paid by the cultivator. Has nothing to do with that. And so when you look at it, this violation, there's actually no violation. What's even more important is the fact that following the statement of deficiencies, when this was brought to the attention of LTL, and we specifically requested confirmation as to what we should be doing differently, the response was, you tell the cultivator to change that. When you get there and it doesn't match up, you tell them to change it, you go back and you wait till they change it, and then you go back and get the sample. Well, that's what's done now because they told us to do it, but the law doesn't require that. And so I would respectfully submit that the violation as complained of does not exist because of the fact that, one, there's no requirement in the law, and two, it makes no difference to the testing process. Doesn't change how they test, doesn't change the results, doesn't change the cost. But I think it's important to note the fact that when staff said they didn't like it, even though they respectfully disagreed, they modified their practice as directed by staff. Paragraphs 90, 91, and 92 allege violations of 453A.6501 and 453D.7551. Specifically, the allegation is the failure to ensure quality standards of practice and supervision of staff. LTL disputes the subjective determination that the lab staff had not been properly trained and supervised when the inspection occurred in December of 2019. Those specific regulations that I cited, they're companion. You have A, which deals with the medical, D, which deals with recreational, so they're the same regulation language. What it specifically states is that you're to have a scientific lab director that supervises and trains staff. In this instance, this goes back to the testimony of the technician. So based on that one discussion, there was a determination that the lab did not properly supervise and train its employees. There are training documents in there. There is testimony from witnesses saying, here's the extensive training that we go through. Here's how we're supervised. I mean, then Director Hefe Yin was on staff, or was there every day of the week. She was in the lab every day of the week. She was checking the instrumentation. She was supervising the staff. She was having engagements with them. They were updating SOPs. The record is replete with that. The testimony is submitted by the respondents demonstrates the fact that there was ample training and supervision. Again, I would note the fact that in your materials, there are ISO certifications from 2019, not what I submitted. They're in your materials. Part of
Objection
that,
again, those documents are not in the record.
yes, sir, the ISO 2019 is in the record. Yes, sir. Thank you. The reason why that's important is because when you require a lab to be ISO certified, that is one of the things that the certification standards look at. Do you properly train? Do you properly supervise? And are the people that are responsible for utilizing the instrumentation and reading the instrumentation, are your scientists, are they knowledgeable about the instrumentation, and have they been trained on that? And the fact that the ISO certification has stayed in place since required in 2018 adequately and objectively demonstrates that the lab did properly train its employees, did properly supervise its employees. So that again applies to paragraphs 90, 91, and 92. Paragraph 93 is the alleged violation of 453.782. That is the regulation that specifically dictates the type of testing that is to be performed by an independent testing lab. It's the factual allegation is the fact that LTL failed to properly test for Delta 8. I've already explained exactly what happened in this instance. You have in your record the SOP from 2019 that shows Delta 8 as being a required test. It specifically states at the top that pursuant to the Marijuana Enforcement Division's notice of October of 2018, we are now required to test for Delta 8. So you have that notification or again, evidence demonstrating we know we have to test for it. We've been notified by the state. You have an SOP that incorporates the obligation to test it. And you have the printout from the instrumentation showing that it was calibrated to test for the Delta 8. The complaint is that you didn't have a proficiency test. And as Ms. Rolalina, who is here today, testified to, it was because of the fact that they could not get the standard. A lot of scientific information, but as I noted before, you have to have the proficiency test in order to perform. They couldn't get the standard. They explained this. They were allowed to proceed with their testing. The fact that Ozzy stated that he wasn't familiar with it or there was some ambiguity, I would submit to you for two reasons. One, because he had a phone in his face and he was being interrogated. And two, because of the fact that the scientific lab director was not allowed to explain to the investigators, we do this, but they didn't feel like, even if they were precluded from having that dialogue with them, that they really needed to go into it much further because the objective evidence shows it. The objective, the SOP, the instrumentation calibration, and then the certificates of analysis, they all show that the lab was performing the Delta 8 testing as required, and it continues to do so. Paragraph 94 is an alleged violation of NAC 453D.405 and 453.764 subsection 1, discarding key laboratory information. This pertains to the utilization of Post-it notes. If you look at the complaint, it states that on 2 occasions they found Post-it notes that had information that looked like it was directing testing, and as a result that qualifies as key laboratory information, and that was improper. There's no definition of key laboratory information within your regulatory or statutory scheme. But I would acknowledge the fact that it is important to maintain documentation and logs relative to the operations of the testing. The instrumentation there are logs that require that the instrumentation show the preventative maintenance. There are logs that require you to demonstrate when any maintenance or any changes are made to the instrumentation. There are logs that demonstrate how the flow of the sample proceeds through the lab. The fact that you have a sticky that says, don't forget to test these, and by the way, you owe Kelly $40 for lunch, is not demonstrative of the fact that the company failed to maintain proper recordation relative to key laboratory information. That was clearly found by staff, but the Post-it notes inflame them. And so for those reasons, we would respectfully submit that there is no law that prohibits the utilization of Post-it notes. As you'll see in your records, there are pictures of the lab. There's a big whiteboard. That whiteboard tracks when the samples come in and the flow of the samples through the lab. What is the difference between the whiteboard and the Post-it? It's a reminder. If instead of using a Post-it, they had gone over to the lab tech and said, don't forget that tomorrow you've got to prep these samples, would it have been acceptable? We would respectfully submit that the utilization of Post-it notes is not a violation of state law and was not otherwise utilized to track and maintain key laboratory information, but instead they were just friendly reminders to staff to perform functions that they were required to do in a timely fashion. Paragraph 96 involves a violation of 453.405 and 453D.764 subsection 1. This is a catch-all. This again goes back to the paragraphs 90, 91, and 92 relative to training, supervision, and maintaining a quality lab. I note for your attention the fact that 453.764 subsection 1 is a requirement the lab follows certain treatises. It's the requirement to have ISO certification and then to adhere to best practices consistent with a number of treatises. And as you'll see in there, there are a number of those that reference specifically AOCA or AOAC. Again, we'll get into that at a later time, but that is the basis for having the exhibit in your packet relative to RSR, or excuse me, LTL being recognized by AOAC as its only Nevada research lab. So again, a violation of a number of treatises without specification as to which treatise or which part of the treatise was violated. That's what the judge found. You violated this, but I didn't articulate which part of it you specifically violated. But staff said that it wasn't good, that your training was deficient. Again, the ISO certification adequately covers that. And now the demonstration of the fact that this lab is the only one in Nevada that is identified as the AOAC Research Institute lab. And I
And then just state an objection to that, Chair. That was not done until I think May of 2021 and was not in the record.
Again. The statements in the document produced by the hearing officer as the corrective plan, other notes in there. Goes through a process. To explain why, but you have a right to put your position on the record, so please do so.
Thank you. So I note the fact that again, that the violation as identified by the ALJ is one for failure to follow the treatises identified in 453.764. However, as noted, there is no specific reference as to which treatise was violated, what part of the treatise was violated, and therefore we based on that, we do not believe that there was a violation. The next paragraph is paragraph 97, alleging a violation of NRS 453A.368. This is the requirements that labs test for pesticides and mycotoxins. LTL has consistently tested for pesticides and mycotoxins. However, this count pertains to LTL's instrumentation and how the lab responded to the equipment while running what we call blank samples. So the system is, the instrumentation is set up, you put the sample in, run 10 samples, then it stops and you run a blank sample to calibrate the machine. Staff did not like the way that let me rephrase that, the MED staff did not like the way that the LTL staff identified errors with that instrumentation. So when they would see things during those blank runs that demonstrated that there was a spike either up or down. And again, this is one of the things that Dr. Luttrell could in a much more succinct and very clear way explain to you how the instrumentation works and why what staff found it was not concerning, and the fact that the lab's response to the instrumentation, their corrective actions were reasonable. But staff didn't like that. It was their opinion that the ranges were too high, that there was a problem. And then they go on to say that as a result of that, again, how the blanks standards are coming back in the calibration machine, that endangered the public. That's a really hard statement to make and everything without any substantiation to it. And that's the conjecture and the optics of this complaint and why I bring up the objective ISO ANAB reviews. You have objective ones in which they identify issues. The expectation is the labs will immediately correct those. And when they do, the certification is granted. And that's the way that this should work. But instead, staff doesn't like the way that the calibration is or the response of LTL, and instead finds that it's a violation. That's a subjective determination that staff didn't like this. Whereas you have scientists who are saying, we're comfortable with what's happening with the instrumentation. And if we see something that is so out of whack, we understand that we need to have maintenance on it, we'll certainly do that. But so this
Understand the position in terms of some evidence. Treatises There's some representation by the administrative law judge at SOPs. What's your position as to that?
That is correct, Your Honor. What happened in that instance is the SOP said that they would test every 10 and they were running it every 20. So that is correct, and we acknowledge that. The SOP said that the blank standard would be run after every 10 tests, and instead the then lab director was doing it after 20. So that was a modification that needed to be made to the SOP to either increase it to 20, but at staff's recommendation, they wanted to maintain it at 10. LTL maintained it at 10. The next paragraphs are paragraph 98 and 102, and those go together because they allege violations of 453D.788 and 453.790. This is the rerunning of the microbial samples. And this is where the summary suspension becomes important. I would respectfully submit to you that, again, if Dr. Luttrell was able to testify, he would explain to you the difference between a retest and a rerun. He would explain to you and a retest is identified in your law very specifically. It is what a cultivator may do when their product has failed, and it is a specific process whereby they contact the CCB, they ask for permission to do a retest, they wait until they're given authority, and then they're told which lab to utilize to do the retest. That is a specific process relative to retesting. That involves, again, a lab going back out to the cultivation site, getting a sample of the same lot, and then retesting. What was done here was not that. The sample was the same as the one that was taken from the cultivation site. It was in the machine, and the scientist, who should have discretion to do their job, reran the sample so as to determine whether or not there were any errors. Not with the instrumentation, but rather with respect to the way it was handled, the way it was prepped. But you've got a very seasoned microbialist at the time who was very particular and very meticulous about her results. And she specifically would run these through over and over again, document it. I mean, the instrumentation shows it, but then she would also document it in her log and everything as to why she did it. The fact is that, and this is the frame of the discussion, when they came out in December of 2019 to do the audit inspection, and they were inspecting the microbial division, they specifically asked about the reruns. And the scientific lab director acknowledged that they were doing them and asked if it was a problem. And staff was like, well, you're just doing it too much. And so the question was, do you want us to stop? Yes. And so it stopped. So I would submit to you that this is a big difference of interpretation and opinion and scientifically based between your staff and scientific labs. Scientific lab directors in Nevada are required to be a PhD or have a master's and extensive experience or an undergraduate degree and extensive experience. Why ask them to have that much experience if they have no discretion to do their job? The objective is not one and done. You don't take the sample, put it in, push a button, and then you get the results. These are scientists, and this is an instrumentation that requires you to read it. And so when you see something that looks as if it's off, why would you prohibit a lab from rerunning that sample? And the difference is you're not going back out to the cultivation site and grabbing another sample. You're not re-prepping it. You're simply running it through your system again and recording the analysis, the results. And then that scientist should have the discretion to report what he or she believes are the most accurate results based on their testing. That's the whole process. And you must keep that in mind respectfully. This is called testing. It's not, again, a one and done thing. And so this is the basis for the summary suspension. There were multiple retests run against LTL. And this is why those documents in our exhibits are so critical, because of the fact that, again, the public notices, which are there, you could take judicial review of them. You had notices go out in mid 2019 relative to samples.
Chair, I would just object again. She's referencing documents that are not in the record and are irrelevant.
For the record, I note the objection. Ms. Rushton, in the process and as a layperson, when testing's done and get a result, one way or the other, and it's rerun, retested, depending on the verbiage you use at the time, is a record made of the anomaly?
It should be. So in the instance of the microbial, oftentimes she would write things such as questionable, but would not expand upon that.
Because I know mixing and matching other things, there were some concerns about in the rerunning, retesting, how many times it got done, whether or not they took the majority of yay or nay or not. And so I'm a little confused as to that, as you're saying, well, they have the right to run a test. It's helpful for lay people. It's helpful obligation for the public to say, okay, when they reran it, they found something they didn't find the first time, or they didn't. And either saying it was the batch or the machinery or whatever, was that done?
Not in every instance. No, sir. It was simply stated rerun, questionable. Sometimes it would, but I would say that and that's probably one of the main concerns that staff had, is that there were multiple reruns, and how did you determine which result to take? And again, I would state that it's not a subjective decision. It's one in which the scientist is looking at the instrumentation. They're familiar. And again, this goes back to being familiar with your customer.
And I go back to, what was the SOP of the lab as of that?
I don't believe it spoke to it at all. And so now they did go back, and they not only did the practice cease on December 9th when they told them that they didn't like it, but in addition to that, they revised their SOP to talk about internal retesting and rerunning. And so as to define the parameters as to when that would occur. And that's why we have no objections to the inclusion of the SOP that was, or the SOD, excuse me, that was submitted in June. We can explain that. I mean, staff says you were rerunning all these tests again and everything. That's bad. It's a repeat offense. Okay, those tests, COAs had already been submitted. This was a new scientist on a new instrument running it to familiarize herself. But it resulted in an SOD and an allegation that we're doing the same thing again. So again, that's why staff is here, and Dr. Luttrell, you want to consider that, we're happy to address that. But the point is that I would say two things. One, we just scientifically disagree with the inability to rerun test. And I would also state the fact that when they told them to stop, they stopped. So you have a demonstration of compliance. You have an unintentional act, because that's not the way that they interpreted. I mean, there's nothing in the law that says that you can't do it. What they said is that, well, no, we define retesting, and that therefore you should infer that to mean you can't rerun. So therein lies the discrepancy. What I think would have been a more reasonable approach to this would be when that occurred and the lab said, stop, fine. And then we could have brought it back to you. At the time, it wouldn't have really allowed for it. But I mean, this is what you open up reg workshops for. Staff has their opinion. The industry has their opinion. Can we get clarification in the law? Because we don't see that as being a clear obligation or prohibition. But your law says that you cannot open up a reg workshop or discuss or look to amend a reg while there's a complaint on file. So no one's been allowed to address this or any of the other issues that are in here since 2019. And then specifically since 2021 when the complaint was issued. I think,
Chair Doug, Ms. Rushton, is it okay if I would like to ask one question? This is Member Young. With the samples that pass, are those ever retested or rerun? I don't see that in there. I only see the samples that have failed.
in response to your question, Dr. Young, the majority of the reruns were done with respect to failing, but there was testimony that there were retests done of passing to ensure that it wasn't a false positive. But yes, that's correct. So
Okay,
not to the extent that with respect to the failures.
Okay, so there, I just didn't appreciate that in the record anywhere, so thank you.
Yes, sir.
Just related to this. It seems like with the heavy metals, there had been retesting of positives, but with aspergillus and yeast and mold, there appeared to be a trend to retest negatives, but not retest positives.
And as noted, member direct to Dr. Young,
Right.
the majority of them were with respect to the failed test and the microbials
Yeah.
and everything. There were reruns done of positives and everything, but not to the extent that there were of the failures.
But that none of those are in the record, right? I don't see a record of retesting positives.
I believe that they are, but I can certainly look at a break and bring that back to you.
Okay, thanks.
Yes. So I think, again, we've noted the fact that one, in terms of the difference of interpretation relative to how scientists operate, and also the immediate response of LTL, I think is a important factor for consideration. In the exhibit materials, exhibit number 6, which were the materials that LTL submitted as part of its hearing packet to the hearing officer, there are the California regs. And I did submit those because it specifically encourages labs to rerun samples when they find anomalies. And so again, it was just simply to say that you're right, you're not Nevada, but other states allow this and it's consistent with scientific practice. So that was the objective of having that in the record. And I would have only put in the one page that said that, but I felt it was improper to not have the complete set of the regulations. With respect to paragraph number 99, there is an alleged violation of 453D.788 and 453.790. This is the rerunning of the heavy metal sample. Again, I would respectfully submit it's very similar to the argument made relative to microbials. And as you noted, Member Durrett, what had happened in this instance is in, I believe, March or April of 2019, the cultivator had submitted a request to do R&D testing specific to heavy metals and cadmium. They were utilizing a new product, and their testing was coming back, or they were concerned that there may be some issues relative to the heavy metals. That was done 6 months before these. These COAs that are before you are 22 COAs in which 5 of them show that the cadmium failed. And so in that instance, as testified to by Mr. Joseph Hahn at the time, the reason he did it is because of, again, just to ensure the accuracy of the results. It had problems with cadmium before. You have now it was failing. Let's go back and check. Now it's passing, but they've had issues. Let's go back and check that too. So the objective was not to skew or to misrepresent the findings, but rather to rerun the samples to ensure the accuracy of them, especially in light of the fact that there have been prior problems with this specific cultivator. And again, I just note the fact that under the regulations that were identified by the ALJ relative to the violations, that pertains to the cultivator's obligation to go through a certain process relative to requesting a retest. Paragraph number 100 alleges a violation of NAC 453D.782 and 453D.790. This is the utilization and development of trend logs. I would respectfully state again that there's nothing in the law that prohibits a lab from doing this. These trend logs were based off of reported COA results. They were not internal trend logs that were done based on the lab's potency testing, but instead they were based specifically on the COA results that had already been submitted to the state. And so this is what's interesting because of the fact that this is a quality chart. Basically, this is demonstrating to the lab by maintaining this where their customers are in terms of their ranges. And so there's nothing wrong with maintaining those and then discussing it with the cultivators. It doesn't, again, diminish the independence of the lab simply to say, here's what you've been reporting and here's what your samples are looking like. And so in this instance, the claim is that they utilize the trend logs for the purpose of manipulating the potency or inflating it. I cannot define what inflated potency is. There's no definition. It's a statement that's commonly used, but there's no definition of it. But the utilization of the trend logs, I would submit to you, is a good practice because when you have objective information, such as that taken from the COAs, and you see that the potency is now swinging one way or the other, it's probably something to take a second look at. I mean, and therein lies the difference. So are we not supposed to be familiar with our customer's business? Are we not supposed to understand what they're utilizing and how they're utilizing it so as to ensure that when we test for it, we get the most accurate results? And I would simply note that based on Member Frolick's familiarity with gaming and everything, you have labs that interact regularly with their customers. And the objective is always the same, to ensure the accuracy of the results, but most importantly, to protect the consumer. And working together to do that, there's nothing that violates it or in any way diminishes the independence of a lab. And so for those reasons, again, the rerunning of the heavy metal samples consistent with the microbials, there's no specific violation, but as directed by the staff, when they told them they didn't like it, they stopped doing it. Paragraph 100 is an alleged violation of 453D.782 and 453D.790. This is again I'm sorry, I just went through that. With respect to the utilization of the trend logs. Moving to paragraph 101, this is an alleged violation of 453.764, subsections 1, 4, 6, and 7, the utilization of a kin sample for microbial testing. What's interesting is, again, that specific regulation is a list of treatises, and the ALJ did not state which treatise or which provision of the treatise was violated by the utilization of a kin sample. And this is what's really important. This is an internal practice by LTL to separate the sample into a kin sample and a microbial sample. It's not mandated. It's just something that they do for two reasons. One, to ensure the integrity of the respective samples, and two, to properly move them through the lab without having to wait. So they would go out and take the sample, and they would, meaning LTL, intentionally separate them into two Ziploc or sealed containers and identify it for their purposes internally as a chem sample and a microbial sample. They get back, the chem department gets their sample, microbial gets theirs. It's not required by law, it's just simply something that they did. And the utilization in microbials of a chem sample in no way changes the results. At all times, those samples stay in a quarantine in a sealed container so as to not allow for contamination. And so the fact that they go over and they utilize the chem sample that's still in that sealed container doesn't in any way corrupt or change the sample as utilized in microbials. The other thing too, as I articulated, is that the microbial samples have to be incubated for 3 days. So again, if there was any cross-contamination, the incubation period would have resolved that. So again, where in the law does it say that you cannot have a chem sample and a microbial sample, or that you're mandated to separate? It doesn't. And where in the law does it say that a microbialist may not use a chem sample? It doesn't. The importance is to ensure the integrity of the sample and to ensure that it's not contaminated. There's no evidence of that in any of the findings or the evidence. And so again, we would state that this is one in which there's no violation because there was no obligation to do it. It's just an internal practice, and there was no finding that the utilization of this internal practice in any way skewed or changed the lab results. The last paragraph is paragraph 103, and this is the alleged violation of 453D.405 and .7641. Again, 764 is the treatise regulation. This is a catch-all. It's basically you acted with impartiality because of all of the other things that we said. And so it's a catch-all relative to paragraphs 98, 101, and 102 relative to the rerunning of the microbial samples. And specifically, I would note the fact that the violation is of 453D.405. That regulation says that if you are a cannabis establishment, you must have dual license, medical and recreational. Not sure how the facts, as alleged, show a violation of that regulation. And that's kind of replete throughout this, to tell you the truth. So you violated a treatise. Okay, which one? You violated the fact that you're supposed to have dual licenses. Well, we did. You violated provisions of 905. Well, those are disciplinary provisions. They're not instructive regulation provisions that allow or prohibit something. Or you violated the regulation that doesn't allow for alcohol on the premises. There's nothing in the record. So as you go through the complaint and you see, again, how you have to match up everything, you also see a pattern of finding specific acts, such as the retesting of the microbials. And then over here, well, that's a demonstration of impartiality. Well, the law doesn't have anything specific to impartiality, but the expectation is that you're an independent lab. You will act with independence. And most importantly, you will ensure the accuracy of your results. And so that's a specific overview of the findings as made by the ALJ and the objections as set forth by LTL. I would strongly encourage, again, if you have scientific questions, as specifically Dr. Young, being a scientist himself, please allow Dr. Luttrell to address those. I think it would be extremely important for you to hear that, because I think it would provide to you, one, an explanation of the actions, and two, a level of comfort that optically this is not a significant or severe case. And it certainly doesn't rise to a level of demonstrating, as noted in the objections, that LTL committed sins. That didn't happen. This is a difference of opinion, but the most important thing, as I've noted before, is that when it was brought to the attention of LTL, even though they disagreed, they completely complied. And with that, I'm happy to answer any questions or to return on rebuttal and answer them at that time. Thank you.
I have a few questions. The potency trend issue, when they had asked the lab, when they had asked Cannex to retest it, some of them ended up, so in the ALJ's, I think it's in the findings of fact, it says the majority of them ended up being, the potency was less. Do you have the numbers on exactly how much it was? I didn't want to go back through the transcripts and find it. Do you know how many were different? How many diverged? Do you know what I'm talking about?
Yes, I do.
And then it says some diverged by 10%. So 2 questions. One, it says the majority. So 6 out of 10 or 9 out of 10.
Mhm.
And is 10% significant? I mean, as much as you can base that on the record we have before us, is 10% variance significant or not?
So in response to your latter question, no, it's not. You're talking about if you're medium range, and I don't believe that this is true, but there is somewhat of a thought in the industry that the medium range is 20%. So again, if you're at a 10% deviation up or down, I mean, you're talking a nominal difference in that potency level. I mean, at one point they said it was like I think there was a finding that there was a 20% difference in everything. So you're talking about a difference between 20%, 22%. I mean, again, that is not significant, but that was also the reason why we included the round robin from the 2016 round robin from the Department of Agriculture, because remember, Dorette, that explains to you why you have differences in potency. It's based on the techniques that are utilized. And I understand that this was internal to LTL, but it could have also been the timing. So the sample that was pulled, I can go back and certainly check that to give you a more specific answer. But if you test potency on Monday and then you test it again on Friday using the same sample, and the likelihood of the potency coming back the same is almost 100% inaccurate. I mean, it won't. That's a better way of saying it. I apologize. Because of the fact that the potency is on a certain part, and that can die, that can change. And again, I would really defer to my colleague, Dr. Luttrell, but I will tell you that you're not going to get the same potency results. But in this instance, you aren't going to get the same potency results because of the manner in which LTL prepped their samples and homogenized their samples. I mean, with all due respect, they had a better technique. And that is really the basis of this. You have information in there from 2017, and I specifically included it because competitors complained about it. They didn't like it. They were better. They have a process that is far superior and they don't want to disclose it and everything, but they were forced to put it in an SOP. That was fine and everything, but that is the reason why you have this. But what's really important as regulators is to understand that you're going to continue to see this. You have regulations that have generic standards. It says homogenize a plant before a sample before you test for potency and then test for potency. That leaves a wide berth of
Let
how.
me go more quickly so I don't get cut off for my questions. To contextualize it a little bit, we require warnings on packaging that an edible product, the potency can vary by 15%, right?
Mhm.
So that's the same, that's potency of THC. So that's similar to the potency of THC we're talking about here, right? I mean,
I would defer. May I ask Dr. Luttrell just to give a response to that, Chair?
I would
I-
object,
I-
Chair, to any
I'm not
testimony
gonna-
being taken here.
If that's necessary to answer the question, question's not going to get answered today.
I think it,
I can confer and get back to you. I can respond to you if,
I think it's the same thing. The 15% variance we allow on edibles is for potency of the THC, right? Okay, never mind. Let me move on from that and I'll go back and look again on my own.
Sure.
Okay, so I see in our regulations that we don't allow the labs to request retesting. We require cultivations to request retesting. We don't allow labs to do retesting, but obviously there's going to be times you're going to rerun your own tests for validity, accuracy. But why would the regs allow you to communicate the results of your test and then run retests to allow for a loophole? So what do you think the intent behind those regs were, and why do you think that was not in violation of the spirit of the way the regs are set out?
so in response to your question, I think that is the statement relative to retesting at the request of the cultivator, there's no verification. It's based on hearsay. That was not done. The fact is that if someone called and complained and said, why am I doing this or why is it looking this way? That's a discussion, but you don't manipulate test to appease a customer. I mean, with members of the board, you're talking about a lab that has $2 million worth of equipment in there. You have a PhD and scientists who are extremely good and well paid. No one's going to fabricate results for the benefit of a cultivator and run the risk of losing their license. So I would submit that you never heard anything but a statement from the agent saying, well, this is what we were told. This goes back to the best evidence. Show me the videos. Show me on your video when you videoed Cafe Yen saying that. We do not believe that's true. We believe the retesting was done by scientists in an effort to ensure the accuracy, to ensure that the sample had not been tainted or touched or in any way it could have given a false positive or a false negative. It was done strictly to ensure the accuracy. And so, I would respectfully disagree with the fact that of the testimony and the weight of the testimony about the fact that this was done for the benefit of the cultivator. It wasn't. It was done to ensure the accuracy of the results.
Would you like to address though why that would happen during failures of Aspergillus, but not after passing results? We kind of touched on that a few minutes ago, but it seems like the motivation was to get passing results.
I think the motivation is to ensure that that the results are accurate. I mean, I can only say that in so many different ways and everything, but when a scientist is sitting there running a test through a machine and sees things that they believe are an anomaly, is there a bubble in the machine? Did someone prep it improperly? Was it dropped? And then they go back to ensure. I mean, on the one hand, you can say that was motivated by the business because of the fact that you don't necessarily want to fail something that shouldn't otherwise fail. But on the other hand, I would say that the scientists don't care one way or the other. Their objective is to ensure the accuracy of the results. And as you've heard from many of your licensees, that the retest is an onerous process and nobody likes it and everything, doesn't make any difference to the lab. I mean, the fact is that you are ethically and scientifically obligated to run the test and report the results that you believe are accurate relative to the sample that is in front of you. And that is verbatim what we testified to and argued during the hearing, and we articulated at the time of the summary suspension, and the lab stands by. And so, again, the last thing I would note to that, Member Durrett, is the fact that it was known that the lab, again, the MED at the time was very sensitive about microbials. You have, again, public warnings and other things stating that retesting had been done on products that were either on the shelf and everything, and that they had failed, and you had the notices go out. So if it was done for the purpose of manipulating the results or doing it strictly for the benefit, why would a scientist continue to do that knowing that the MED is now looking into it? I mean, the fact is you have the documentation that demonstrates that she was rerunning them. And why? I mean, and specifically the number, you have the instrumentation. It's almost like a consciousness of guilt. If I was doing something wrong, I would have stopped as soon as I saw that notice in September that went out to say, hey, we've identified these samples and they failed a second test for microbials. I mean, that's not what was occurring. And that is specifically why when Director Yen said, is there a problem? Is it against the law? No, you're just doing it too much. That was the response from the agent. And so they stopped, but it wasn't done for the purposes as articulated by staff. And that's an inference. I mean, that's their conclusion. But we can tell you as scientists that that's not at all what occurred or the reason for it.
So, like at least a quarter of these are, the violation is, like you said, it's a not following one of these treatises. Do these treatises to a certain extent carry the weight of the law? You know, good lab practices, if you're not following the good lab practices, that's a violation.
Correct.
How does every single mandate in these treatises, every single sentence in these treatises are incorporated by reference in the regulations, or how do you guys expect to, how do you handle following all of the treatises? What does that approach look like?
Well, you can't. I mean, the easiest thing to say is that if it was a treatise that had specific cannabis related obligations and they said follow that, but most of these are generic. I mean, they apply in part to cannabis, but they really apply to just good lab practices. And so again, before you get into the section relative to the treatises, it talks about the ISO certification. And that coupled with the AOAC are very high standards for labs to meet. And it's a good standard. I mean, that gives you guys as regulators the objective understanding as to exactly where the labs are. But Member Durrett, we asked that question repeatedly, like what part of the treatise and why is this treatise referenced and what is the significance? Because a lot of them are dated. I mean, even the pharmacopoeia that I rely on that's in your packet and that is identified here is from 2014.
There are going to be parts of it that if you don't follow that, if you have a glaringly obvious violation of good lab practices, that is going to be a violation of that of 0.788, right?
Correct.
And then warrant discipline.
But it's also hard, Member Durrett, because of the fact that, again, when you stop and look at the importance of regulations, they're supposed to give you guidance. So you have the statutory scheme and what the legislature tells you to do. And then as an administrative body, you go back and you promulgate regulations to ensure that the directions are clear. When you just list a significant number or a handful of treatises and you don't identify which parts of those are the ones that you want the labs to follow, how do they know? I mean, I would just state the fact that for the most part, I would submit, and again, not speaking on behalf of any of the lab, that they simply look at the ISO certification because that therein has the standards relative to independence, objectiveness, reliability of results, accuracy of results, supervision, training, and most importantly, quality controls and quality assurances. You have a mandate. Remember, Durrett, that's where some of those treatises are important because those were the ones that set forth standards relative to quality control and quality assurance. That's what this board needs to do. You need to have regulations that really do specify what the expectations are. Otherwise, it's just going to be exactly why we're here today. It's a matter of interpretation in which staff sees it one way and the lab sees it the other way. But it doesn't make it wrong. It's just a difference of interpretation. And that's where I keep coming back to the compliance. If you disagree, you have an ability to ask for advisory opinion or open up a reg workshop. But the most important thing is to do what you're told to do until you get that clarification, because we respect the regulators and that's what their expectations are. But I would say, and I think it's important, this complaint has served as a notice to the industry as to what this administration's interpretation and application of the law is. That's not right. The notice to the industry should be done in clear regulations, technical bulletins, other things that give guidance and everything. But now we have a complaint against the licensee, and now all the other licensees are told, okay, you can't do this, you can't do that. This is what the expectations are. Some of them are clear, they're the border, the completion of metric, but the other ones, again, are open for interpretation. And so,
Ms. Rushton has that last comment. Interpretation.
Excuse me, Mr. Chairman, can you get closer to your mic?
Yes, ma'am. As to your last statement, expectations and all the treatises and trying to figure out what's red, what's yellow, what's green. Cannabis compliance to some degree also lies upon the SOPs that the licensees put forth that they say they're going to follow. In your view, is that appropriate or inappropriate? And that's where some of the reading through all this, just the high point, some of the differences come into play that the SOPs that were put forward by the lab, rightfully, wrongfully, they didn't adhere to their own SOPs. As you're saying, the technical part is out there, but then we kind of expect, they say they're going to do this, they're going to follow it. How should we consider that?
well, and that's an important point. I do believe that the obligation is that you adhere to your SOPs, and you're allowed to create those based on the instrumentation, the scientists, and again, how you believe is the best method for performing that set of tests. There are times, Chair Douglas, when the science changes, the instrumentation changes, and the SOP doesn't change fast enough. So I would give a little deference in that instance. There were 2 specific violations that we acknowledged. There was a complaint about the utilization of a pipette versus the flask. We pointed out that the SOP said it's discretionary, you can use either, and that it didn't make any difference. There was the SOP relative to when you would run the calibration. That wasn't done, and it should have been done and everything. So again, they say you need to go back and modify the SOP, but you're right, it was out of spec with the SOP. And perhaps there is something that you could, and to what degree of being out of spec does it constitute a violation? And at what point of being out of spec does it constitute a violation and a claim that you acted with impartiality and endangered the public? That's what the complaint said with respect to that CCD, the calibration being out of whack, endangered the public.
And I guess to that retort in terms of how is the board to view if the metric policy that was set forth is not followed or your SOPs are not followed? What's a danger and not a danger to the public? How are we to judge?
Well, it is in your former capacity with respect to being a judge, it's a matter of looking at the weight and determining the seriousness of it. I mean, what we submit is the fact that the mycotoxin and the pesticide testing and the instrumentation was done properly. It was how the instrumentation, when it acted up, was recorded and the response of the staff that was the objection. And so we believe that, and again, Ms. Romalina, who testified at the hearing, is here and can explain that when they would see these anomalies, they would record it, they would look at it, discuss it with the scientific lab director, and make the next step in terms of how to handle it. And in instances, you might have to call out the equipment manufacturer, in this instance, like a Waters, and have them come out and do preventative maintenance and recalibrate the machine. Other times and everything, you can just determine internally that you're okay. And so in those instances, I mean, again, we don't want to wait till someone gets sick to have an issue or to say that that rises to a level of being a concern. What I'm saying is that this was not with respect to the testing. This was with respect to the maintenance on the instrument. And I understand that if the instrument's out of whack, you could get false results and everything, but that wasn't occurring. And they were demonstrating how they were addressing it internally with the instrument. And so it's a long-winded question, but again, Member Douglas, as we progress as an industry, I think it's going to become very clear as to those instances in which the public is truly at risk and those instances in which it's a difference of interpretation as to how a lab handles the instrumentation versus the way that staff wants them to. But staff told them how they wanted them to. They issued a cease and desist to ensure that they did that, and then they recalibrated the machine and continued to retool it.
As is some of the things that are listed, one of the things that stands out, and you've touched upon it slightly in terms of the industry. Labs in particular are creatures that rely upon information that's produced by the various testing, so on. The agency is relying upon information that's produced by following certain rules and reporting systems to make judgments for the protection of the ultimate consumer. And that's a concern. So I just state that for the record. If you have something to close with, please do so. If not, we will.
I would just note-
Unless a board member has another question before we take a break at this time.
Just in conclusion, Chair Douglas, I think it's really important about your last comment. Today, you have a much better set of regulations and standards based on what this board has seen in the industry, what your staff has brought to your attention, what the licensees have brought to your attention, and your responsiveness to this. This was not the same in 2019. And please remember the fact that this industry from 2014 through 2019, again, you had different regulators, different sets of law, and really very little guidance. And so for those reasons, I think it's important to note the fact that there was a lot more discretion in interpretation. That's the reason why the SOPs were important. But those anomalies that we noted in terms of one, the pipette versus the flask, I don't believe that that was a violation of the SOP. The calibration, we understand that that was in the SOP and it should have been done and it wasn't. But again, we can articulate the reasons why that did not pose a threat to the public or endanger the safety of the public.
Hearing no further questions, we'll excuse you at this time. We're going to take a 10-minute recess. You said you were going to attempt to look up something and you could find the piece of paper and all the paper. I know it seems like a paper drive. My house has, like cowboys and Indians with a fort, all my boxes on this
They
thing.
may recall.
With that, we'll take
Yes,
a
sir.
10-minute recess.
In my office, there's huge. You're up after. Fill it with like.
We're back on the record. Presentation on behalf of the Cannabis Compliance.
Thank you, Chair. Again, Senior Deputy Attorney General Christopher Rath, appearing as counsel for the Cannabis Compliance Board. We did make some objections to the hearing officer's findings, and I will discuss those. I do want to be very clear, however, that if this board adopted the hearing officer's finding and recommendations in whole as written, we would be perfectly fine with that. The result was 100% correct and appropriate. You only have about a 2% disagreement on a few of the specific findings leading to that result, but not the ultimate decision. The hearing officer's findings of fact and conclusions of law should be granted great deference. The hearing officer is an experienced senior administrative law judge with the Department of Taxation. She has undertaken the massive task of reviewing all the exhibits in this case, hearing all the testimony, and providing a thorough analysis of all factual and legal issues in this matter. Her findings and recommendations are your map in this case to review each of the key issues and the supporting testimony and evidence for each of the violations. In fact, the hearing officer's findings are about 90 pages long. They contain about 350 footnotes, which pinpoint what evidence, what testimony, and what exhibits support her findings. And for that reason, they should be granted great deference. I'm going to incorporate by reference all the arguments I've already made at the hearing, including our opening and closing statements, as well as the arguments presented at the September 22nd hearings on the motion to dismiss. So what I will do is I will walk through the hearing officer's findings and indicate where we have some slight disagreements with them. And I think that will also serve to address my rebuttal to the respondent's objections. I would encourage the board, after we're done here today, to look thoroughly again at the hearing officer's findings, and also to look thoroughly again at the objections stated by both the parties, as well as those responses to those objections. I think those are really the key documents to look through. It's probably helpful to look through some hearing transcripts here and there, and particularly probably the parties' closing arguments at that hearing. Before we walk through the hearing officer's findings, I want you to keep some background issues in mind. There's really three basic themes to this case. One of them is compliance, one of them is honesty and integrity, and the third is public health and safety. Respondents' counsel queried the board at our last meeting on this case, asking how much compliance does the board expect from its licensees? The answer to that question is pretty simple. The board must expect full compliance, or at least pretty close to that, from its licensees. As you can see from the hearing officer's findings, the testimony, and the evidence, the board received very little compliance from its licensee. As to honesty and integrity, this is key for all cannabis labs, and they know that. As has been noted by the board and others in prior meetings, cannabis labs are the gatekeepers of this industry, and they are there to ensure the public health and safety by accurately testing cannabis and cannabis products to make sure they are safe for public consumption. They are also in place for the public trust and confidence so that consumers have the information they need to know what substances are in their cannabis. All labs must be unbiased and strive for the most accurate results. They must put accuracy over aiming for higher profits and attaining more businesses, which flows directly into the next theme, public health and safety. With retesting cannabis samples multiple times after failing results and reporting results with quality control failures, no one really knows how much of any microbe or potentially dangerous material is in their cannabis. At this point, the point here is that where there is at least a potential for harm, and we have a lot of these category 3 violations that are defined as violations that create potential threat to public health and safety. To prove those category 3 violations, we only need to show that there was a potential for actual harm, but not the actual harm. More important, really, is the public needs to be able to trust test results. NRS 678A.005 subsection 3 states, public confidence and trust can only be maintained by strict regulation of all persons, locations, practices, associations, and activities related to the operation of cannabis establishments. Retesting until you get the results your clients want is patently dishonest and dangerous. It's like getting a positive COVID test from a medical lab, then pushing that medical lab to keep testing your swab or blood sample until they get a negative result so that you can report a negative result and go back to work. Beyond that is the intentional false statements that we have here, Category 1 and Category 2 violations. Significant discipline is necessary for any dishonesty with a regulatory body, or else there can be no public trust or confidence in the industry. Strict regulation mandates a truthful and forthright licensee. False and misleading statements must not be permitted if the public trust is to remain. Strict regulation does not mean a slap on the wrist for merely putting forth a plan of correction and then not even bothering to follow through with it. I'd like you to keep that in mind as I walk through the hearing officer's findings, and we'll discuss where they were correct and note where we have some minor objections to them. Again, as a reminder, this hearing officer sat through 20 days of a lengthy hearing, was able to assess the credibility of the multiple witnesses. As far as scientists, they had their 2 scientists testify. We had our 2 scientists testify, and the hearing officer was able to reach a decision based on that. More importantly, as I'll get to later, we had a 3rd scientist testify. Respondent's own senior microbiologist, Yin Zhu. Ms. Zhu's testimony is critically important. She worked at the lab. She felt she had to resign her position due to the ethics of what was going on, and I'll get into that further later. So what I'm going to start with here is I'm going to run through the hearing officer's finding of facts and conclusions of law. I'm going to do that in order. I think all of you may have the findings of fact in front of you, should you want to reference it, but I'm going to go in direct order first of all. So looking under Roman numeral 1 of the hearing officer's finding, first of all, the hearing officer found by a preponderance of the evidence that the CCB had proven that respondent did not have a designated security manager or director and did not follow a security plan, thereby concluding that the board should find 1 Category 2 violation. We agree and have absolute no objection to that finding. There was some discussion by respondents' counsel about, oh, well, they needed this training and we didn't do it until they told us to. As Ms. Rushton indicated, the facility has been open since 2016. Why did they wait 3 years to get the training to implement their security director? Why did they have to wait for the regulator to tell them to follow the regulations? That objection is not valid. The licensee was not complying with the requirement to have a security manager or director and have them properly trained, and hadn't complied for 3 years. Failing to have required security measures shows a lack of compliance. It also impacts public health and safety by allowing for cannabis diversion and other crimes at an unsecure location. The second part of Roman numeral 2 involved the blockage of security camera.
Before you go further, just to try to
Sure.
deal with the matter. Ms. Rushton made a as to 83 and security training that she referenced the section the board had to tell the licensee and forward with that.
I think what she referenced was, and I don't know the exact section she referenced, but she mentioned a reasonable time. And my argument to that is 3 years is not a reasonable time.
I believe that was enacted in 2018, right? At the earliest, and I think most labs.
I
had
think there
lighter
were
ones.
emergency regulations prior to that 2017, which were in place and were probably similar.
I can tell you the security director requirement wasn't enacted until 2018 at the earliest.
Well, I mean, we still have over a year. Why is that? I don't think over a year is a reasonable time, and I don't think that the regulator needs to tell them to prompt them to comply with the regulations.
The purpose of the question, though, is whether or not the statute that was quoted puts the onus on the board to do so. And if you know, based on your reading of those regs.
I don't believe it does. The onus is on the licensee to follow the regulations and not take a year to wait until someone tells them to. Moving on, the next violation addressed was the blockage of security camera. I think the regs were clear that we should be able to see everything with the security camera. We did not prevail on that one. I respect that. I have no objection to that finding. The second section of the hearing officer's findings involved record keeping and documentation issues. And this is the issue with metric that we discussed. The hearing officer found that respondent had failed to comply with Nevada law with properly inputting data into metric on over 10,000 separate occasions, and therefore recommended a category 3 violation for these omissions. As you heard respondent today, they basically minimized that issue, indicating they forgot to push a button or a couple buttons in metric, but we never got an explanation as to how they forgot to do this over 10,000 times. And some of these items were not updated from the 2017 summer suspension. Fact is, they were simply repeatedly ignoring the requirement to update their cannabis inventory and metric. The hearing officer found no mitigating circumstances. Respondent acknowledged these failures. We do agree it's a category 3 violation. We did take issue with how many category 3 violations there were. It's our position the board may find over 10,000 separate violations, which would dissuade other licensees from repeating the same mistake over and over again until caught. We'll leave it up to the board. I'm fine with leaving it up to the board to decide if it's 1 or 10,734 violations. This is a problem that was originally found in 2017, so it is a repeated issue. And Chair, it's my understanding you do not want me to get into the penalty discussion. I know there was an objection to that, so you want me to leave that alone.
Yes, please.
As to the stacking issue, which was brought up, do you want me to defer on that as well or address that too?
I think that goes to the first part in terms of if in fact they're correct, if there were numerous violations, that's important for the board to understand.
Okay. So I will address the general stacking issue once we go through the hearing officer's recommendations. The next recommendation in this section under Roman numeral 2 involved the research and development banners in the certificates of analysis, which I'll refer to as COAs. Nevada law requires it. It's quite simple. That happened on 9 separate occasions. Respondent admitted to these omissions, again, tried to minimize them. The hearing officer recommended 1 category 3 violation. We agree with that. The banners are important to alert consumers, other cannabis facilities that the testing has only been done for R&D. And in many cases, that R&D testing is not complete. So it's an important flag for the CCB and for anyone else who looks at these. So our only objection there is it should have been 9 category 3s instead of 1. We'll leave that up to the board. Again, on the metric issue, it is important that the seed to sale tracking requirements are followed and kept in place. The seed to sale tracking requirements are important so that you can track the cannabis from seed to sale. When you fail to do that, cannabis goes missing. You don't know where it is in the metric system. That leaves it open to diversion. So I just want to reiterate that it is a very important issue to follow metric, not only for compliance, but for public health and safety and to avoid the risk of diversion. So the third issue under Roman numeral 2 was the issue of the COAs misrepresenting the testing results for samples of flower when they were actually trim. The hearing officer noted that this amounted to making 5 false statements to the department concerning the products respondent had tested. The hearing officer stated that correct designation of product is important to ensure proper chain of custody and test sample identification, because trim is collected in lots 3 times the size of flower, and therefore it costs more to test the flower. The taxes for the flower are higher, and those misrepresentations do have an impact. While respondent wants to say that makes no difference, it actually does. It lowers the cost for their clients. Clients don't have to pay as much tax. They don't have to pay as much for testing. It lowers their clients' costs. And to simply blame the cultivators doesn't cut it. Their own standard operating procedures require verification of the type of cannabis being tested. When it comes in, the lab knows if it's flower or it's trim. If they don't properly record it, then they're just ignoring the issue. So the hearing officer found one Category 1 violation for intentionally issuing false statements to the department. Fully agree with that. Our only objection here was that there was at least 5 separate false statements, which should be 5 Category 1 violations. We'll leave that to the board to decide how many violations. The 4th issue addressed under this subsection of the hearing officer's finding of facts and conclusion of law is this respondent's failure to maintain records of laboratory testing information. This is the post-it note issue, of which you heard quite a bit about from respondent's counsel. Post-it notes were used to instruct lab staff to conduct retests, and then they were discarded and not kept in the lab files as required by Nevada law. As the hearing officer found, these records constituted technical records which had to be retained. Obviously, respondent did not want to retain them because, as I'll discuss later, the retesting was improper and illegal. Respondent made light of this issue at every opportunity they had. The claim was CCB was just attempting to ban the use of post-it notes. Mr. Rushton laughed about this when he gave his testimony on it. Respondent didn't take this seriously at all. The point is not post-it notes. The point is these were instructions to retest cannabis improperly, and they were discarded, hiding key laboratory evidence. The violations addressed in this section, that's Roman numeral 2, demonstrate multiple compliance failures. They impact public health and safety, and that failing to follow required seed-to-sale tracking requirements corrupts that system, leaves cannabis open to diversion. Importantly, the false statements about the type of cannabis tested implicate outright dishonesty, respondents' record-keeping representations to the board. The same, again, is true for the hiding of key laboratory testing data on post-it notes that were discarded. The 3rd section of the hearing officer's findings involved improper laboratory practices, which can be found under Roman numeral 2 of the findings. The first issue addressed in this section involved respondent improperly providing test results to clients prior to reporting them to the department, which is not permitted under Nevada law. What we heard from respondent today was that all they did was, somebody called up, they gave a status report of where the test was in the process. That's not what happened. I encourage you again to read the hearing officer's findings and look at the evidence. And this will be important for the next sections we deal with. NAC 453D 788 subsection 9 specifically says, a marijuana testing facility shall file with the department in a manner prescribed by the department an electronic copy of the certificate analysis for all tests performed by the marijuana facility, regardless of the outcome of the test. And those must be provided, quote, at the same time it transmits those results to the facility which provided the sample, close quote. They are supposed to, at the same time, transmit the test results for all tests. They don't get away with it simply by calling a retest a rerun or a preliminary result, and then only do that for failures. What other labs do or do not did or do not do or did do doesn't make a difference here. We're looking at this particular lab. If other labs do it wrong, they're going to get caught. Anyway, based on the evidence, the hearing officer found that respondent intended to allow its clients to have possession of test results that it did not provide to the department, and thereby found a Category 1 violation for intentionally concealing evidence. We fully agree with that results. The second issue addressed in this section involves respondents' failure to maintain required standards of practice and failure to adequately train its lab staff. As noted in our closing statement at the hearing, respondent largely staffed the lab with employees fresh out of school and or very early in their careers with little experience or training. That would be fine if proper supervision and training was undertaken, but as the hearing officer found, it was not. The hearing officer's finding documents numerous instances of failure to properly train and supervise employees and the consequent mistakes they made due to these failures. She found one Category 3 violation here, and we agree with that. This violation clearly implicates public health and safety, and that testing results are questionable when lab employees do not know how to do their jobs properly. There was training documentation provided that's in the record. I will note its training documents provided by respondent were incomplete and do not show that every employee attended all the training programs they were supposed to. The third issue under this subsection addresses respondents' inability to accurately report results of Delta 8 THC levels due to its employees' failure to follow the lab's own standard operating procedures, or we can call them SOPs. The evidence demonstrated the key employee responsible for this analysis simply could not properly read and interpret the HPLC machine's output, precluding accurate results. And the hearing officer found that these were not mere isolated incidents. This was not a one-time issue. He was under pressure, supposedly, from an investigator. The investigators here looked at a number of the outputs from the HPLC machines and found that they just were not read properly. And that again goes back to proper training and supervision. The hearing officer recommended a Category 3 violation here. We agree with that finding. It again implicates a potential to impact public health and safety when certain THC concentrations cannot be accurately determined. The fourth issue addressed in this section was the unsanitary methods used for homogenization of cannabis, which was then ultimately used for microbial testing. On these issues, the petitioner showed a video at the hearing of employee Luling Wang homogenizing cannabis for chemical sampling. It is obvious to even someone who doesn't work at a lab that he never used anything close to sterile technique. I'm sure you've seen the video, but just to reiterate a little bit, he'd take one sample, crush it up with his hands, put it back, and then the next sample, he'd rub his gloves without changing them with isopropyl alcohol, which can destroy microbials. And then he wouldn't change his gloves until after several uses of them, contaminate them with other samples, which could also affect heavy metals and that type of thing. The issue here is not the separation of chem samples from microbial samples. The issue here is that the chem samples were ultimately used to test for microbials at certain time. The hearing officer specifically found that this potential for contamination could lead to inaccurate or false results for microbials. As a result, the hearing officer found another Category 3 violation here, and we certainly do agree with that. Again, inaccurate results for microbials can potentially impact public safety. The fifth issue the hearing officer addressed in this section involves respondents' continued reporting of test results for pesticides and mycotoxins where there had been quality control failures that were never properly investigated or corrected. The lab's instruments exceeded quality control tolerance limits, and the lab staff never properly resolved these issues or simply dismissed them as monitor and see without proper corrective action plans. Again, as the hearing officer detailed, the labs did not follow their own SOPs on this issue. Importantly, the department had identified this as an issue in respondent's 2017 summary suspension, and there were again issues at the 2018 inspection. The hearing officer found yet another Category 3 violation, and we agree with that. The fourth section of the hearing officer's findings involved respondents' unauthorized retesting of samples. The first issue dealt with in this section was the retesting of microbials. This can best be summarized in a direct quote from the hearing officer, and I'm taking this directly from her findings. When a sample failed microbial testing, respondent engaged in the practice of retesting the failed sample. Respondent did not report the initial failed test to the department and did not seek permission to perform a retest. Respondent did not perform the retest following documented invalid results to prevent false positives, to confirm the failed test, or to confirm the amount of microbial contamination in the sample. Respondent performed the retest with the goal of obtaining passing results to report to the department and its clients. It was even in respondent's own SOPs that it was to report all results to the department at the same time as the clients. The evidence for the hearing officer's conclusions was thoroughly documented through the lab records, emails, and testimony. The one former lab employee who testified was Yin Zhu. She was the lab's senior microbiologist, and again was so disturbed by the ethics of this practice that she resigned her position. Due to these illegal acts, the hearing officer found that respondent had committed one violation of NAC 453D 905 3A3, which is making an intentionally false statement to the department. The regulation lists this as a Category 1 violation, but the hearing officer found it to be a Category 2 violation. I do also want to comment that this is not simply a difference of opinion as to what a rerun is, what a retest is, what a preliminary result is. The statute clearly indicates that you do your test, you get your results, you report them. And I will point out that Ms. Wayman, when she was going through this, is if there was a documented issue, a documented anomaly, she didn't count that in her 232 retests. She only counted retesting when there was no documented anomaly. And consistently, these retests were for failed results. If a result passed, it wasn't retested. Yin Zhu was asked this question specifically. Were you ever requested to test when a sample passed? No, only failed samples. If you're truly retesting for accuracy, you're going to test just as many passed samples as failed samples. That didn't happen here. Our only objection here is that while citing the violation as intentionally making a false statement, which is a Category 1, the hearing officer found a Category 2 violation. There is a Category 2 violation for making unintentionally false statements, but in this case, I think the hearing officer found the intent was clear and proven. I don't know why that happened. It may have been because the hearing officer felt the violation, even though intentional, fit better as a Category 2, even though it was intentional. So I'm going to leave it up to the board to decide whether it's Category 1 or Category 2. And again, it really should be 232 separate intentionally false statements as opposed to just one. And that's not even counting the fact that some of these retests were done up to 4 times to get the desired result before reporting. Respondent was caught doing 232 documented illegal retests for microbials. There may be many more than that. Ms. Zhu testified that this practice started in 2018, and 232 is a number which is just a snapshot over 3 months. Ms. Wayman testified to that at the hearing. Again, I'll leave it up to the board to decide what category and how many violations those are. These violations are particularly troublesome. As the hearing officer noted, respondent failed to comply with the regulatory system that ensured honest test results. They kept retesting until their clients got the result they wanted, not for accuracy. Respondent withheld failed test results from the department and the public. They tested and until receiving a pass result, in some cases, even when they knew the facilities had contaminations problems. Again, I'd encourage you to look back on Yin Zhu's testimony on this issue because it's really key. One point that really needs to be brought up too here is respondent's unfortunate attempt to really besmirch Ms. Zhu's testimony. She questioned another witness, Mr. Rushton, about a supposed dispute over an unemployment claim. She never produced that document. We objected to that testimony. It came in. That's fine. But no document was ever produced to prove this, and Lynn Zhu herself was not asked about it. Hearing officer saw that as a non-issue, apparently, in her findings. Another troubling issue is respondent attempted to belittle Ms. Zhu by claiming she needed a translator to fully understand some of the complicated questions by counsel. That's really just a disparagement, does not call this witness's credibility into question. This section also addresses some other unauthorized retesting, which is really, again, pretty similar. A similar issue occurred with retesting of heavy metals. This happened 22 times. In one of those instances, there were up to 6 tests before reporting one final result. Another example, multiple retests were done for cadmium at one facility until a passing result was achieved, even when respondent knew the facility had an issue with cadmium. The only objection here is that, well, twofold objection. The hearing officer found one violation for these intentionally false statements and stated it was a category 2 instead of category 1. Our objection here simply is it should have been 22 violations and they should have been category 1s as intentional. Again, like the prior violation, this retesting issue is serious and shows a lack of compliance, disregard for honesty, integrity, and impacts public health and safety with inaccurate testing results. The third issue dealt with in this section deals with respondents' unauthorized retesting for THC potency results. As you're aware, the respondent utilized trend logs for cannabis potency testing, conducted unauthorized retesting of potency, and contacted some of its clients to discuss quote unquote preliminary testing results prior to notifying the department of these findings. The hearing officer specifically stated, quote, these actions show that respondent was not merely reporting results of potency tests it performed, was working with its clients to increase the potency reported. And that's really the key issue. The issue here is not use of trend logs per se, it's the manner in which the trend logs were used. And that was to help the clients increase the potency reported. Again, these very same issues were part of the 2017 summary suspension, yet they continue. They clearly show intentional conduct. Hearing officer again found a category 2 violation. Since it was intentional, our only objection is that it should have been a category 1 violation, and there were at least 56 separate violations here. Overall, the multiple retesting violations encapsulates the basic theme of this case: non-compliance, lack of honesty and integrity, and disregard for public health and safety. Again, lab testing should strive for accuracy and not be results driven simply to satisfy customers. And again, I want to point out, both sides presented their scientists. The hearing officer evaluated the testimony of each side's 2 sets of scientists and made a correct decision here. Also taking into account the third scientist, Yin Zhu, who really didn't have a dog in this fight. She wasn't working for the lab anymore, and she had simply substantiated her testimony, which she had previously told the investigators at the time of this incident. The 5th section of the hearing officer's findings involved respondents' quality control and quality assurance program. This is listed out in great detail in her findings under subsection 5, which really only deal with quality assurance and quality control issues. The hearing officer addressed 5 practices showing respondent was not adhering to required QA/QC programs. All labs are supposed to have adequate QA and QC programs. Some examples of this were failing to take corrective actions when the HPLC machine exceeded tolerance limits in pesticide testing, a repeat violation from the 2017 suspension. There was the issue of respondent using spreadsheets to communicate potency testing results, but these spreadsheets were incomplete because they did not include all the cannabinoids for which respondent was supposed to test and varied from analyst to analyst. There were a couple others and also included the fact that respondents' proficiency testing for 2018 and 2019 was incomplete. It failed to conduct proficiency testing for Delta 8 THC and CBDA. The hearing officer found one Category 3 violation after hearing all of respondents' excuses, and we fully agree with that. Again, these violations demonstrate lack of compliance and potential threat to public safety due to inaccurate test results. The sixth section of the hearing officer's findings involved respondents' failure to act with impartiality in the testing and reporting of results for 5 separate clients. This does repeat some of the issues, but these are very distinct. And I'd note that you can have, one action that results in more than one violation for different reasons. The hearing officer really summarized this section well. And I'm going to read a block quote from her findings of fact and conclusion of law. And again, everything is footnoted as to where the sources come from her findings. Hearing officer stated, respondents' practices with these 5 clients show it was not acting impartially and objectively in its testing. The evidence of record established that respondent used unapproved retesting practices to increase potency results and avoid reporting microbial and heavy metals testing failures. Respondent did not charge its clients separately for those retests, but built it into the cost of doing business, thereby indicating that retesting for desired results was an integral part of the services provided by respondent and an anticipated cost of its business model. Respondent performed retesting and cultivated increasing potency results because its clients perceived the benefit from higher THC potency results and therefore preferred increasing potency results. Respondent's clients financially benefited from fewer failed microbial and heavy metal testing failures because they were able to sell rather than destroy failing product. Additionally, at least one of respondent's clients financially benefited when it tested flower but reported it as trim because the client could pay the lower taxes due on trim. In all of these instances, respondent was engaging in practices which benefited its clients but were in violation of Nevada law. The hearing officer appropriately found a violation of NRS or NAC 453D 905-383, which is making an intentionally false statement to the department. Again, our only objection here is it should have been a Category 1 instead of a Category 2 violation, and there should have been 5 separate violations for 5 separate clients. Again, these violations clearly call into questions respondents' honesty and integrity as it put its financial interests well ahead of accurate test results. Sum up, even if the board overrules any or all of our objections, we're fine with the result the hearing officer received. I'll address a few of the other issues raised now. First of all, there is a complete record in this case. Everything that went before the hearing officer is in what you have, as well as the pleadings beyond the hearing officer's findings of fact and conclusion of law, which were done afterwards. The summary suspension concluded if any party wanted to include any of the documents in the summary suspension, all it had to do was submit an exhibit. And we did that. There were documents in there from the summary suspension that I think we put in and were admitted, and there may have been some from respondents. And by the way, the hearing officer only excluded 2 or 3 of respondents' exhibits. Most of them came in. And the ones that didn't come in, you have as part of the records. Again, one of which is 140 pages from California regulations, which they don't have any relevance here. So the record is complete. Dr. Luttrell, he was properly excluded. The hearing officer was granted the right to manage the case and how it procedurally proceeded. She set deadlines. She also moved deadlines. And we entered into a stipulation at one point saying, here are the cutoffs for documents. Here are the cutoffs for disclosure of witnesses. Both parties agreed to those deadlines. And then one of them didn't comply. Dr. Luttrell was disclosed late. The scope of his testimony was never timely disclosed. On the eve of the hearing, it was ultimately disclosed that he would be acting as an expert with no expert opinions being provided. Regardless, Dr. Luttrell's resume, which is in the record, shows that he never even worked for LTL during 2019. So he had no direct knowledge of the violations. His testimony didn't have any relevance to begin with. Again, you still heard from their scientists. In fact, 3 of them when you count Minju. Another issue was raised that we should have given up the entire investigative file. The law, as we discussed at the motion to dismiss session, the law does not allow for full discovery of an investigative file. Only those documents that we decide to use at the time of the hearing. Discovery is not required in administrative law cases under the Duchess case. If there was any so-called exculpatory evidence, this magic box that we're supposedly hiding, Kennex had it. They had full security surveillance. They could have gone to their security cameras and taken any recordings they wanted. Another issue is that we were, unfair with the employees there. That's just not the case. If Ozzy had been there only a few months, then why was he given so much responsibility on this particular machine without any supervision? Some other issues I'd like to address. Respondent has repeatedly claimed that it's mere correction or even just the promise of correction or a plan of correction absolves it of all the violations in the complaint. There's no such proposition to be found anywhere in NRS Chapter 233B, which doesn't even apply here, or NRS Chapter 453A, or NRS Chapter 453D, or the NACs, or any place in Title 56 or the NCCRs. The hearing officer properly ruled on that issue. If it was the case where they could simply just correct something and move on their merry way, then they could simply commit many serious violations, correct them, promise to, and then merely continue to commit the same offenses and continually correct them. That's an absurd result that was never contemplated under any cannabis regulatory scheme. Regardless, Respondent pledged to correct 2017 issues when it was summarily suspended then and did not do that. It had other violations in 2018 and more violations in 2019 when it was summarily suspended a second time. Clearly, Respondent cannot maintain or will not maintain any plans of correction that they promised to follow. And their claim is that they are in compliance and remaining compliance is fallacious. In fact, they continue to repeat their serious violations. In response to our objections, the document which is in the record in this case, Respondent states, quote, "The fact that LTL has not been issued a statement of deficiencies nor complaint pertaining to its operations since 2019 is prima facie evidence of Respondent's compliance," close quote. If you take that for true, then conversely, a statement of deficiencies or since 2019 would be prima facie evidence of Respondent's non-compliance. The fact is, as noted in CCB's opposition to Respondent's motion to consider motions to dismiss, Respondent was issued a statement of deficiencies letter on June 24, 2022, in which inspectors continued to find multiple violations at that lab. This was from a March 2022 inspection and shows that there are ongoing violations. The copy of the June 2022 SOD is contained in the materials I presented to you in the notebook. There has been no objection to it, so you're free to look at it. Many of the violations were similar to the complaint before you now, if not the same. They included unapproved retesting of heavy metals, failing to follow the lab's own SOPs, and reporting pesticide and heavy metals results with failing quality controls. They're still back and forth on a plan of correction for that investigation, and that has not been completed. In fact, they're still not compliant, still dishonest, and still endangering the public health and safety. Correction of issues, even if it did fully occur and was maintained, again, does not absolve them for any of the penalties of the violations. I'd like to address stack. Did you want me to address stacking issues?
If you wish.
Sure. Let's talk about the stacking issues. Their position is that progressive discipline cannot occur until a violation has been fully adjudicated. This is going to lead to unwieldy results if you take that for true. So to give an example, if a licensee committed 3 fully separate and distinct and different Category 3 violations on or about the same date, under respondent's reasoning, then CCB would need to file 3 separate complaints for each such violation, adjudicate the first complaint, then file a second complaint and adjudicate that, and the same for the third or other violations thereafter for progressive discipline to apply. It's obviously a waste of resources, and all should be handled in the same complaint. More violations within a certain time frame are meant to be progressive, because when you have multiple violations, it demonstrates the licensee has pervasive issues in operating its cannabis business. So as long as you have separate and distinct violations, there should be stacking, because there's different violations of the same category within the 2 years under NAC. Under NCCR, it's now 3. We're looking at 2 for this case. There's a separate stacking issue for multiple violations that are the same, which I have already addressed with you. For instance, when they make the same mistake 10,000 times or 200 times or 500 times, it's our position that those should also be progressive. That I'm fine with leaving up to the board to review the specifics of this case in that regard. Clearly, if there's separate and distinct category violations, it should be progressive. The statute doesn't say it's not. And it's a waste to fully adjudicate it when you have the evidence there already in one place. Next, I want to address the repeated issues of these samples from labs who retested the cannabis that LTL had repeatedly retested, which occurred at the time of the summary suspension. As I've repeatedly stated, that is completely irrelevant. It does not matter, and I stated this in closing argument, it does not matter if the new labs all reach the exact same results as LTL. The only issue in the complaint before you is the fact of illegal retesting and colluding with clients to get the best results, which is the dishonesty issue here. Whether other labs got different results doesn't matter. What matters is the illegal retesting and the consultation with clients. Again, summary suspension in 2019, that proceeding is over. They resumed operations. As we and the hearing officer have repeatedly stated, nothing precludes a disciplinary action after a summary suspension proceeding. Otherwise, a licensee would never be held responsible for its violations. Another tactic addressed here is respondents' claim that simply because an accrediting agency accredited them at one point, that means they are in full compliance. That is belied by the clear language in the NAC, as well as the NCCR now, that states, quote, inspection by an accrediting organization is not a substitute for inspection by the department. There are reasons behind that directive. Accrediting agencies are new to cannabis and are not always up to speed with or know all the regulations each state has, and do not as thoroughly investigate licensees on the regulations. Accreditation visits are often scheduled and not random like the CCB investigations. Regardless, as the regulations have stated, they are not a substitute for inspection by the regulatory agency. One issue I'd also point out is if you are to consider this accreditation that happened in October of 2022, which was after all this stuff happened. The summary I provided you in my materials shows that that accreditation was extremely limited They were not doing a lot of, do you want me to go there? If I
Let
can,
me weigh in at this point. As a 2022 accreditation agency issues and as to um, allegations of violations cited in 2022, if they have any place, it's in the area when we get into deciding whether or not we decide violations, and we have to look at what type of infractions are we finding? Category 1, category 2, how we deal with those. That may be appropriate for both sides to talk about for that, not for this. We're looking at the events that took place prior to that.
okay, I'll move on from that then. Another issue raised was the way that the hearing was held and the supposed bullying by inspectors and I suppose attorneys as well. That just didn't occur here. The inspectors were doing their jobs. They did not come in like a raid. They gathered data, they gathered evidence, they recited the facts when this hearing was held. Recitations of facts and law with arguments supporting CCP's position is certainly not bullying. This is a disciplinary action. The parties are going to disagree, and each side has the opportunity to make its argument and evidence. If they want to talk about bullying, there's some other issues that need to be raised. We had our direct examination of Ms. Wayman, the chief investigator. We took a day to do that. They spent 4 days on her cross-examination, repeatedly asking the same questions over and over again. They wouldn't have stopped unless we'd objected to it. Ms. Perez was also subject to cross-examination on multiple days. I've already gone over the treatment of witness Lynn Ju. So there's just no bullying here. It's just prosecuting a case and defending it. That's it. Again, at the end of the day, it is important to remember and this licensee's past history of suspension and other violations. They were suspended in 2017, had repeated deficiencies in 2018, and a huge number of violations in 2019. Basically, there's systemic issues with non-compliance, culture of satisfying customers and maximizing profits at the sacrifice of compliance and safety. And that's why a senior administrative law judge found the violations she did in this case. Are there any questions from me? I think that covers all of my rebuttal and what was in the hearing officer's report.
Board members,
I have questions. I'm going to try to get through them quickly. So please don't try to anticipate your argument. Please try to answer the question so I don't
Sure.
get cut off from being able to ask questions. I don't want to rehash arguments, you know?
Sure.
Okay, so there are circumstances, right, when they can rerun or retest and not report, and it would make sense. Like you saw with the cadmium testing, they were retesting failures. So are you saying that every single time equipment runs a test and there is a valid result, that has to be reported as a COA? Or is there ever an occasion where they could redo it without reporting it?
Yes. If there are clearly stated anomalies, like I think the example used was there was a bubble in the test machine or something like that. If there was a clear anomaly, it was documented, and they put down the reason why they thought a retest was appropriate, then I think that's fine.
Yeah.
It's these situations that we have where, and Ms. Wayman looked at all this and didn't count those things as retests.
So is there an occasion, and I really just want the information, is there an occasion where there's no anomaly, but it's okay to do the retest? Like they're just doing their own analysis of the performance of their equipment. There's no anomaly. Is there ever an occasion they can do a retest without reporting it as a final COA,
No,
where it would not be a violation or a concern, a red flag?
no, there's not. I mean, they test their equipment with quality control procedures and check the variance with that, which as you know, is another issue.
So I know Ms. Wayman took out any of the occasions where there was an anomaly, or so it shouldn't be in that data set. Did
Right.
she look at that 2-month period and see if there were any times that they did retest something that had already passed with regards to aspergillus or yeast and mold?
Yes, I believe she did. She did not note any passes which were retested.
Okay.
Now, there were some cases, I think, for the heavy metals where, they randomly decided to take 2 out of 3 and see which one, see if there was 2 passes, then they'd report a pass with 1 fail, and that was done a few times. And that's not it. That's not anywhere in their SOPs. And this generalized retesting with no anomalies, again, not in their SOPs either.
This is just something I didn't want to go back and dig and find myself. Was retesting an issue in 2017 or 2018?
I do not have that in front of me. I think it was for potency in 2017. That's my recollection.
So I don't want to go too far down this because we're not discussing what penalties should be, but I think it's something we have to just look at today. If there's something that was a technicality, and then we substantiate that violation, that could lead to enhanced violations down the road, right? So how does that work? So for example, something like not having the banner, something that's not a public health,
I'm sorry, not having
the red banner on the R&D,
Uh-huh.
something like that. If we substantiated that as a category 3, how does it work for enhancement purposes in a separate case down the road?
So under the NAC, there was a 2-year look back period. Under the NCCR, there's a 3-year look back period. In this case, since the NACs were being applied, I would say there would be a 2-year look back. So on the date you adjudicated, if they have another category 3 within 2 years from that date, and it's adjudicated, then it would be progressive.
Thank you.
Does that make sense?
Thank you. Okay. And then just this is ditzy, but like these trend logs, how could they be used in a purpose you don't want them used? The potency trend logs. Is the idea that a lab would want to show, look, we're showing that your potency is going higher and higher? What would be the motive a negative motivation here?
That's one way of using them. Also, I think what they also did was when they tested the potency and wasn't falling within those trend logs, then they'd want to go retest it.
Okay. I have a few more. So, because again, this is like a quarter of the entries in the complaint. There are times when the good lab practices carry the weight of law, and it would absolutely be a violation to not follow these good lab practices. They're incorporated through the NCCR. That's sufficient. There are times when it wouldn't be, correct? Like not every single word of every single one of these treatises is enforced. We're not even going to try to attempt and say that that's the case. So is that correct?
Let me address it the same way I did in my closing argument. I think what we're really talking about here is standard of care. Obviously, the medical board doesn't have regulations which instruct you step by step how to perform surgery or anything else for this matter, but this is a standard of care. What would a reasonable chemist do the same way? And we had different testimony on what the standard of care was. You heard from our scientists, you heard from their scientists. So it's a matter of good laboratory work practice. What's the standard of care for a lab? And the hearing officer assessed that for all of the witnesses that testified.
Well, I think we need to further discuss and develop that. Where is that line? When are these absolutely we are going to impose a violation for these, or these are treatises that we needed as guidance at the beginning of the development of this industry, but really there's a departure from some of the parts of these. I think we need to further parse that out. I do just a couple more. Was there a period when they labeling of trim versus flower that was found, I think, 5 times or something. Was there, did the inspectors or auditors look back and see if that had occurred more than outside of those instances?
I
Were they
think,
still looking in that 2-month window that they were looking at everything else, or what was the?
I mean, the dates were the dates on each of the manifests that were submitted, and I think they were all around similar time. But out of 8,000 pages, I can't tell you the
Yeah.
dates on them. I'm
It's okay.
sorry.
So if you don't have the banner on the R&D, it's the concern that now that product that was the subject of the research and development can get sold to the public, or is it more, no, this is just the requirements, you have to follow the requirements?
Well, it alerts staff at the CCB to know that this cannot be released to the public because it's R&D only.
It's labeled as R&D, right? It just didn't have the banner in addition to being
Yeah,
labeled.
and
as
remember, we're getting thousands of these in constantly, so you're going to need that red flag.
R&D. But the concern isn't that it did get sold to the public because it didn't have the banner.
I don't know that any of it got sold to the public.
And then the last one, and this is maybe a little more argumentative, so feel free to address this as an argument, is you want 10,000 violations imposed. I mean, if we impose 2,500 on each of those, it'd be $30 million. Why do you want that?
You have absolute discretion as to you could assign
We could just-
you could assign $1 to each of
This
them.
is up to billions of dollars. Like,
Again, you have discretion. You can assign $1 to each one of them.
why do you want? What is the interest in imposing 10,000 violations? What's
Because-
the public interest in that?
It's because if you don't do that, once they make the mistake, they'll keep making it, and know there's only one violation at the end of the day. And this was an issue from 2017 as well.
Okay, thank you.
I'll leave that to your discretion, but that's my position.
Any of the other board members wish to ask questions? Thank you.
All right. Well, I do want to thank the board for taking the time here. And since I probably won't be up again, I also want to thank the hearing officer, the witnesses, and most importantly, our investigators for their hard work in this matter.
Thank you.
Thank you.
Ms. Rushton, do you have comments?
I want to address a couple of just inconsistencies in the response provided by counsel. The microbialist at the time, Yen, had been with RSR or LTL since its inception. She left in March of 2020 because she retired. She did not leave because of this. The testimony did not reflect that. She left because she retired. And during Mr. Rushton's cross-examination, it was asked if he was familiar with her departure from LTL. Yes, she indicated she was retiring. All right. Did you ever hear from her again? Yes. She contacted me and asked me to change the designation of her employment status to fired. And I received a letter from Dieter specifically asking me to confirm whether or not she retired or she resigned or she was terminated. You have an obligation to be truthful. He confirmed the fact that she retired. So you have to give weight to her testimony to the fact that she asked him to change her employment designation and he refused to do so. She worked for the company for a number of years and never used an interpreter, never needed an interpreter. We not only worked together, we socialized with the members of the staff. At no time did she ever have an interpreter. When she stated what she did during the hearing and my cross-examination, it was specific to when you were told to retest by Mr. Rushton, did you have an interpreter? No. Okay. Who was present? I don't recall. When was it? I don't recall. She was not clear on the dates that she made that statement was made to her. But what she was clear about, and please review the record to confirm this, I am a seasoned scientist. I stand by my results. She specifically stated that she did not fabricate results. She did not give false results, and that she stood by her scientific accuracy and the results that she reported to the then MED. I think that's very, very important to note that. I think it's also important that you understand a little bit more comprehensively the value of the ISO certification. That ISO certification is an objective standard that mandates that you demonstrate quality assurance and quality control standards against your SOPs and against the state of Nevada cannabis standards. It is specific to cannabis. There are a litany of ISO certifications, and Dr. Young is likely aware of this. Some apply in the medical field, so there are a multitude of them. But the one that is specifically obligated here, 17025, is specific to the cannabis industry. And that is the standard that is required. And if you look at that, it's codified in the federal regulations. It specifically obligates labs to maintain control charts. Control charts are the equivalent of a trend log. And the reason why is because when you have the trend log and you're seeing deviations from it, then you go back and you retest. I mean, that's the whole point of it. And so I think it's very important to understand that you can state that the actions were done for financial reasons, but there were never any financials demonstrated. There was never any testimony from a cultivator saying, yep, I financially gained. It was a snapshot from a dispensary's like pricing sheet that showed that higher THC content sells better. So you take that, and then the fact that you have the control charts, the trend logs, and then the complaint that was made by a competitor that started this relative to potency inflation. And that's where you get the conclusion that it must have been done for financial reasons. That's not correct. ISO mandates control charts be maintained by labs, and that's what they did. But I'd also state to you the reason I indicated earlier that there's no such thing as potency inflation is because it's the potential potency. The objective is to ensure that the consumer knows the potential potency of the plant that they or the product that they are going to consume. There is no reason to inflate it. It's a
Ms.
misnomer.
Maxson, I'm sorry, it's Rushton. It's hard going back so many years. On that issue, there's judicial notice I'll take in terms of what's out there because of litigation across the country on the issue of potency testing, inflation,
Certainly.
going on right now.
Right.
That's a reality.
You're
So
absolutely correct.
It's a open subject. Just leave it that way, but I'll allow you to make your argument, but I just want that for the record.
Certainly. And I'm aware of the case relative to Steep Hill in Arkansas. I'm also aware of the cases that are taking place right now in California. That's called dry labbing. It's called falsifying documents. It's called making up numbers and putting them on a COA to benefit your client. That did not happen here. We are looking for the ultimate, the potential, so as to ensure, again, that the consumer knows. The reason I noted the potency inflation term as being somewhat fuzzy is because there's an assumption that the higher the potency, the greater it sells. That's certainly not true. That may have been an assumption years ago when we were in the infantile stages of the cannabis industry, but it's like saying that you're going into a bar and you order a glass of wine. No one asks, can you tell me what the alcohol content of the wine is? Because it doesn't matter. It's how it appeals to you, how it tastes to you. So cannabis has terpenes in it. Different people like different terpenes. Some people like the sativa versus the indica. There are a multitude of factors which motivate a consumer to choose a specific product, and it doesn't always pertain to the potency. So again, it's a gross assumption to say that this was done specifically for financial reasons when you have no other evidence than the isolated, like connect the dots. Also, I think it's a misstatement relative to the 2017 summary suspension. I've included the documents in the materials in front of you. They were submitted to the hearing officer that specifically dealt with the potency. There was a complaint from a competitor about the potency. The summary suspension was issued. Jorge Pupo was the director at the time. We went in and said, what's the problem? He said, I don't know. Why did we suspend? Well, because the potency looks really high and the competitors are complaining about it. He said, go fix your SOP. Give us $1,000. They report that it was a $5,000 fine. I have the information in there that it's $1,000. It's little things like that that are just inaccuracies, inconsistencies, things that just lead you to believe one thing when they're absolutely not the truth. That's why I so heavily rely on the ISO, because it's objective. The ANAB certification that is done is objective. And in the instance, and everything that there's an issue that's identified, it's expected that they will immediately correct it. And if they don't, then it leads to a lack of certification, which means you can't operate.
What's the date of that certification for the record?
The original ISO certification are the ones that are in your records, are
One
specific.
that you're referring to.
There's one from 2019 during the applicable time. And then as a result of a complaint filed by the
Was it
CCB against my client,
Applicable time, was it before or after?
it was during. Yes, sir. They had the ISO certification at the time of the 2019 inspection.
Thank you.
And then the latter one, like I said, was done in October of 2022.
Chair, I'd just like to object to what council testified to as to the CCB filing a complaint with the accrediting agency. That did not happen.
And we respectfully disagree. My staff is here.
We note both positions
Yes,
for the record.
So I also think that it's important to note the fact that when you talk about the CCB not being unbiased, that's not correct. That's simply not correct, because if so, you would look to the ISO. You would respect the fact that there was a corrective action and plan, and the representation that it was not followed through with is not correct. It was followed through. The 2022 SOD is just that. It's an allegation. We responded, it's still open. And the retesting, if you want to know the specifics, we can tell you all about it, because it has nothing to do with this issue. But optically, it sounds bad. So it makes you believe that this is a continuing thing. But that's where we go directly to the violations and the stacking. You can't do it. The law says a prior violation or a violation within the 2 years. That infers that you have been adjudicated as committing a violation. If it's just the fact that someone says, well, you violated the law, that doesn't mean anything. Look at it in the criminal sense. So think about it in this context. Someone has a DUI, and in that first DUI, they injure multiple people. It doesn't elevate to a DUI third. It's a DUI with harm to this individual. But the fact is you cannot elevate that until you have a prior adjudication. And progressive discipline is set forth in the objections is founded in employment law. And it's also consistent in 233B, because what the objective is to say, all right, you as an employee have violated the terms of your employment. You've done something that's inconsistent with the law, but instead of just firing you, we're going to give you progressive discipline. It means that there's been a finding. And so when you look at the stacking that was done by the judge, that's where we fundamentally disagree. If she finds that there is a category 3 violation for not putting the banner, that does not necessarily equate to a second category 3 violation because of the fact that they didn't click the metric button. What happens in those instances when you look at progressive discipline, there is an understanding that the licensee knew that these violations, that these acts were violations, and they continue to commit them. That's not what happened. In a 3-day period, they came in, they found a multitude of what they considered to be alleged violations, but you can't stack those because they had no notice. The 2017 summary suspension, as I said, was based specifically on the potency. There was a 2018 summary statement of deficiency, which did specifically state about the metric, and we acknowledge it. She just didn't click the button. It doesn't minimize the importance of that. There's a reason why you have the seed to sale, and we certainly recognize that. There was the adequate documentation, though. So if you had to go back and verify because metric collapsed or there was something, you had the supporting documentation demonstrating that the destruction had been done properly. And I think that, again, that is extremely important. When you go through the hearing officer's findings and you look at the respective violations, if you take out the stacking, her fine amount is $122,500. I mean, that's where we are. We obviously disagree with that amount because we believe that these were things that were matters of interpretation and as a mitigating factor that when they complained about it, they were corrected. But to talk about anything further than that It is inconsistent with 233B. And while you may not have an obligation to adhere to that now, in 2019 you did. And what that specific section says under 233.127 is that you may not suspend or revoke without giving a licensee the opportunity to demonstrate compliance. And only then, when they cannot demonstrate compliance, do you have the ability to, again, go forward with more punitive actions such as suspension and revocation. That's not what occurred here. I mean, in this instance, again, we've explained exactly why there's a difference of interpretation. But I think that the comment by counsel just sums it up. Prosecuting a case. This is not a prosecution. This is not a criminal case. This is a disciplinary administrative action in which, again, your obligation is to look at the facts and determine whether or not the violations were intentional and whether or not, when they were brought to the attention of the licensee, they corrected them. And thereafter, if you believe that it's necessary to impose discipline, such as a fine amount, that's within your purview. But they're asking you for punishment. That's why I included in your materials the quotes from the objections made by Ms. Balducci. The sins, these aren't sins. I mean, the sins, that's a horrible way of putting this. Not to mention the fact that when you look at the closing statements, I mean, the way that the staff was referred to and their expertise and their background, it's demeaning. That was demeaning to staff. But it has been one constant act like that ever since. The fact is that there is a bias by the CCB. And counsel enumerated that to me last week when he said no settlement because of the animosity between the parties. We have no animosity towards the state. I can't tell you the tremendous amount of respect that I have for state agents and how hard that they work. But the idea of a regulator having an animosity against one of their licensees, that's disheartening. That demonstrates to you why we're here. That demonstrates to you why the comprehensive corrective action plan that we requested and that we submitted should have been sufficient. It's also the reason why at some point there should have been a discussion relative to settling this matter before we launched into a 21-day hearing, until why 8,000 pages were dropped on this and then told go to hearing. So I note that for your attention because of the fact that if you keep that in mind and you separate it and you actually look at the facts and then you rely on the specifics and the objectiveness and the integrity of the ISO certification, it demonstrates to you that this was a matter of interpretation. But regardless of the interpretation, agree or disagree, change the practice and did exactly what they said to do. And I think that that is, again, extremely critical.
Ms. Rushton, clarification. During the process before the administrative law judge, did you ever make a request for a settlement conference, or is it your belief the animosity is too great to have a settlement conference?
In response to your question, we did not ever tender a settlement offer, Chair Douglas, because of the fact that at the time that we refused the settlement offer in 2020, following the summary suspension, Ms. Balducci wrote back, and it's in your file, fine. Then all offers are rescinded going forward, and just know that we're going to continue to investigate until we get what we want out of this. No settlement offer.
As to the proceedings that we're in right now,
Yes, sir.
no request was made.
No, yeah, well, no, sir, not before the hearing. The law does require the hearing
You
officer.
answered my
Yes,
question
sir.
because I'm aware of what you're going to.
Mhm.
Law requires the hearing officer to ask. But you've answered.
Yes, sir. So no, there was no settlement offer made until late last week, and then that was rebuked. And so, again, the attempt was to, as I stated earlier, to come in and give you the breakdown of what we think would be a reasonable resolution to this matter, and it also coincided with the settlement offer that we submitted last week, which again was rebuked. The response was, you can sell your certificate.
I'm
take
going
a
to object to any
six-figure fine.
settlement discussions
We'll
You
coming
can
in.
sell your
We'll
certificate and
strike
take a
that from the record at
six-figure
this
fine.
point,
Please strike that.
noting that the opportunity was available, was not,
I
did
Oh.
not go forward. And also it's noted that the hearing officer did not ask the question.
Certainly. The only other thing I would note for you is in response to Member Durrett's question about the retesting, there is testimony specifically in the record from the state's agents about when retesting is allowed, when reruns are allowed. And it's very consistent with what we've stated and what Mr. Rath has stated. It's when you see that the instrumentation or that, well, it's when the instrumentation gives you a reading that you don't think is regular or normal. You don't know what the basis of it is until you do the retest. So you have the result come back. You see something that looks like an anomaly. You don't know what the reason is. You don't know if it's the bubble. You don't know if it was because of contamination until you run the retest. And that is consistent with the testimony that was provided. And specifically when I asked Ms. Perez, are there circumstances? What happens if the machine goes down? Well, then you document this, you fire up the machine, you attempt the preventative maintenance, you rerun the sample, but you don't go get a new one. And so again, there are those circumstances. It's a matter of documentation. So in their opinion, the documentation done by Ms. Yen in microbials, when it said retest, questionable retest, should have been more specific. All right. It's not what ISO requires, but if that's what the state requires, that needs to be done. And I think, again, going forward, that is a good standard for this board to consider in terms of defining the parameters of reruns and reanalysis for the lab industry. Differentiate between the retests, because you're not going back out and getting a sample. But when you are going to rerun, not rediluting or reprepping the sample, you're just rerunning the machine, explain why you're doing it, and then why the necessity of doing the multiple test. Those are not inconceivable practices, and they would certainly give your staff a level of comfort that there wasn't manipulation. The only other things I would just wanted to point out is with respect to the summaries that were provided in the materials. We did object to those during the hearing. You have a number of what they call histograms. So when you have voluminous documents that you want to summarize for a hearing officer, you can do that, but you have to provide the materials that you relied on in preparing the summaries and the histograms. Those were not provided to us. So we're in the hearing. All of a sudden, the histograms go up and they show all of this information about the labs and their potency testing. And the objection was made. These are summaries under Nevada law. Regardless of the regulation, Nevada law, it says that if you're going to submit summaries, you've got to provide us with the information. Did not provide us with the information. There's also the presumptions under Nevada law. And while it's a disputable presumption, there is a presumption that had those samples that were relied on to suspend my client and to issue health notices tarnishing their reputation, if those samples had been provided to us, the presumption is that it would have been favorable to us versus not favorable. We weren't provided those. Again, multiple requests. We request to have the information suppressed. It wasn't. And as it again relates to those health notices, there was one that was done in February 2020.
Ms. Rushton,
Except
you're
that-
getting, on rebuttal, you're getting far outside of what was stated.
And Chair, I'd just like to make another objection. We were limited to an hour apiece. Ms. Rushton's now got an hour and a half,
I
excluding.
understand the time, Council, but
Thank you.
this is rebuttal. I'm allowing her to go through the points, but certain points are outside the scope of what was offered in response to your initial. So they're inappropriate.
Certainly. I'll leave it with this with respect to the hearing. At the end of the day, Nevada law, NRS 47.040, defines the rules of evidence and errors. It then goes on to talk about, again, presumptions, disputable presumptions, and then under NRS chapter 48, it talks about relevant evidence generally admissible. An arbitrary deadline set by this time and the inability to supplement with information as it becomes available to you when you're looking at 8,000 pages that were dropped on you 2 months ago and everything is not unreasonable. We should have been able to present our case. We were not able to present our case. And I guarantee you, as I stated before, if you would allow Dr. Luttrell 30 minutes to explain this to you, you would have absolutely zero concerns about this lab. I appreciate your consideration, the time afforded us today. As Mr. Rath indicated, I ask that you please go back and review the objections because they're very thorough and very detailed as to our respective positions. And I'm happy to answer any questions that you may have.
Anything additional by a board member they wish to ask? So she sits down.
This is Member Young. I just wanted to follow up with Ms. Rushton. Did you have any specific examples where with the testing that we discussed, where a past test was retest? You said that was somewhere in the documentation. Do you have any examples of that?
No, sir. The only thing when I asked staff, again, with their familiarity of the evidence, we think that that was possibly just limited to the heavy metal retesting.
Okay.
So that you had the pass and then retesting, and then you had fails that were retested. But I think that that was just limited, Dr. Young, to that heavy metal testing.
And I guess I had a follow up on the retesting. I certainly understand when there's anomalies and you have to rerun the test. I mean, for example, if you put something on the HPLC or the mass spectrometer and something shows up that's not supposed to be there, isopropyl alcohol or something that you wouldn't expect, that you would say, well, gee, we need to rerun this because that shouldn't have been there in the first place. My concern, I guess, is just it seems like the only time that these things were rerun was when they failed, and that it wasn't. I'm looking for the anomaly that you mentioned, and is it documented anywhere that anomaly, be it a bubble in the machine, or like I said, for my example, they find something that just shouldn't be there and they felt that they needed to rerun it. Is that documented anywhere?
I don't know if it's documented in your files or in the evidence that's in front of you. In terms of ours, our LTL, going back, Dr. Young, and looking specifically through the 2019 microbial, we could certainly check and follow up with you. And that's something that I could submit to council and just say, here's the instances, or I can certainly go back and re-review the evidence that's in there relative to the microbial testing. I just can't tell you with absolute certainty. I apologize.
No, that's okay. It's certainly understandable. It's just my concern is just it seems like the only anomaly is the failed test.
I don't know if that's true. I just can't answer it, but I will tell you that it could be that when a scientist looks at something and they're confident about the pass and they pass it, but then they look at something and it fails and they believe that it needs further examination and evaluation. I don't know that there's a standard that makes one okay and one not. But I could certainly go back and look at the number. And it could just be based, as you are, I think, inferring, or concerned about, Dr. Young, was it a rapid amount of retests done just for the negative or just for those that failed? And why was it so disproportionate? And that's something that we can certainly go back and check. And I apologize that I don't know off the top of my head.
Yes, sir. Thank you.
And just for the record, I would object to any further new evidence coming in at this point.
No, sir, and I didn't mean that, but what I could do is go back and look through the evidence I apologize, the evidence that's in the record.
Okay. Dr. Young, you have anything else?
No, thank you.
I have a question. The administrative law judge, when she made her decisions on training, relied mostly on Ms. Perez's evaluation of whether training was sufficient. I know it's impossible to do this off the top of your head, but if you could, are there instances from the record that you can cite to about what would establish that Mr. Ruiz's training was sufficient?
Certainly. I think it's interesting that the state really continues to refer to Ozzy as a scientist. He was not. He was a technician. He was in training. They move around to different stations and they're trained on certain functions. And at that time when they came in, he was training on that equipment. And so that is, and Ms. Romalina, I think, gave pretty extensive testimony about, one, how their training process works, and specifically how Mr. Ruiz's training was conducted, because she did it. And so in the record, I think that there is a very detailed explanation about Ozzy. But what was even more important was the fact that, again, we repeatedly tried to explain to Investigator Perez that he was not a scientist. He was a technician who had been there for less than 6 months, and he was in the process of learning the machine, that particular one on that particular day. But that is not indicative because of the fact that he couldn't answer the full spectrum of questions about the instrumentation. It's to a lack of training. So the scientists come in. There is an orientation program. There is an obligation for them to look through all of the SOPs and to also review corrective action plans, internal, not with respect to the CCB, but corrective action plans that have been done on the instrumentation that they are going to be utilizing primarily. And then after that is done, we have a compliance QA officer that signs off on it, then the scientific lab director signs off on it. Then they're allowed to start working on the machine, but it's in incremental stages until the scientific lab director determines that they're proficient to utilize the machine and run the test independently. So that's their general standard of training.
Okay, thanks.
Any board member have any other questions? Thank you.
Thank you very much for the consideration. I appreciate it. And again, if there's any follow-up questions, please let me know.
For the record, before we adjourn this or things, number one, if this supplemental documents that have been offered today have not been given to the cannabis compliance, it will be provided to cannabis compliance. They were provided to the board members and other council. I don't know if they've been provided to department, but to make sure that so they can be marked, because providing them to us by themselves doesn't get marked. So,
Ms. Verkler has been provided with them from both sides.
all right, thank you. Secondly, as to our recorder, if she is on the record, how long will it take you to get a transcript of today's events?
Yes, it will be about 3 weeks.
I don't know how the other board members feel about this. I'm of the inclination where I'd like to see a transcript, because a number of things got said today. I'd like to go back and check. That is me. I'd like to hear from the other members what their comfort level is, whether they are willing to rely upon their notes or whether they would wish to see a transcript of today's arguments.
Chairman, do we have the capacity of looking back at the tape, rewatching it, or is there a Zoom? Okay, and that would help me until the transcript is ready.
Other members wish to weigh in.
Member Drat, I'm okay with waiting. I think it's unfortunate for it to extend longer, but it's much more important to be accurate and correct.
This is Member Young.
Member
I would appreciate deferring until we have the transcript also.
Same here.
Thank you. I know it's always a shame when events have anniversaries and birthdays, but based upon the arguments that have been offered, we will not reconvene until after we have a transcript provided to us so we can review it and then come back into deliberation to decide what we're going to do with this first phase of this event in terms of making the final decision. So we would stand at recess unless there's something else for the record. And I digress because I always forget that we do have, since we are required even with these to have a second public comment period, we should have the second public comment period. Seeing no one in Las Vegas, do we have anyone in the north? We are adjourned. Thank you. It wasn't.